Good morning, everybody. Happy Tuesday. Welcome to TCF Live. I am Dan Soul, and I will guide you on this 3-hour journey through Courtlandia, starting with Magistrate Urich.
My client's being charged with 1 count of operating while intoxicated, 1 count of open intox, and then a civil infraction of speeding. I did get a chance to go over those charges with my client, as well as her constitutional rights. At this time, we would waive formal reading and ask the court to enter a not guilty plea on Ms. Brown's behalf. Set this for a formal pretrial in front of Judge Kolakowski. And Ms. Brown does wish to keep MIDC counsel on. I believe that she qualifies.
That is all very good news. So Ms. Brown, you understand what's occurring today is your arraignment. So not your last court hearing, your first court hearing in this matter, correct?
Yes.
All right. You'll have any number of additional hearings depending on how you and Mr. Shreeman intend to manage this case. But for right now, a not guilty plea is entered on your behalf, and you will stay in Mr. Shreeman's good hands. You will be receiving a notice to Commons. It will direct you when and how to appear for your pretrial in this matter. And in the meantime, Mr. Shreeman will continue working with you. So together, the two of you can make a plan as to how you're going to make your way through this challenge.
Yes.
Are we good so far?
Yes.
Thank you. Now, the court has to consider bond in this matter. Bond is not intended to prejudge or punish you, but bond is required by statute in order to ensure that you do reappear and that you pose no threat to the public. So the court will now hear from your attorney, Mr. Shreeman, as to why you should remain in the community during the pendency of this case. Mr. Shreeman.
Your Honor, I would note that Ms. Brown is here on time. She's ready to go. I spoke to her yesterday, and she is taking this case very seriously. She's been very interactive with me. Ms. Brown has no prior criminal history and works as a home health care aide as well as at a hotel, so she's working 2 jobs locally. She really, can't afford to have a warrant out for her arrest and can't afford to miss this next hearing, as she's taking it very seriously and wants the best outcome for this case possible. I would ask the court to consider a personal bond in this matter, given all that information. And Ms. Brown does understand that the court's likely to impose some sort of testing regimen, which she's very willing to do at this time.
Very well. Ms. Brown, as the court said, our constitutions presume you innocent, but the court must set certain conditions to make sure that you're making good decisions going forward, you're clear-headed, and you're posing no threat to yourself or others. You're in a very manageable spot here. These conditions apply to your release. You will appear as directed for all your future dates and abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. Please don't commit any crimes on release status, but do notify the court in writing of any changes in your contact information. Ms. Brown, you'll be making reports to pretrial services. Do you have something to write with by any chance in your vehicle?
Yes.
Okay, take this number down, please.
Okay.
248-451. That's Oakland County Pretrial Services. That's an agency that you will not need to report to in person, but they will be managing your testing regimen and your supervision. So from this day forward, you're ordered to refrain from the use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician. There will be a testing regimen the court will describe more fully below. Please don't enter bars, clubs, liquor stores, casinos, or dispensaries. And Mr. Shreeman is a relatively, we're still over 0.08, obviously, but relatively on a spectrum more modest BAC, allegedly of 0.13. So the court believes we can try 2 ETGs per week for alcohol. Ms. Brown, that is a urine-based test to detect the prior consumption of alcohol anywhere up to about 96 hours prior to sample collection. We'll give you every benefit of the doubt, Ms. Brown. So there'll be an initial controlled substance screen. And if that's negative, there need be no further testing. But if it's positive, you'll be tested 3 times a month for controlled substances. And at this time, the court will set a $2,500 personal bond. So you don't need to post any money with this court today or any other day as a bond unless and until you start missing court dates, violating bond conditions, rejecting rational advice. If those things occur, you could end up owing the court $2,500 and a bench warrant could issue for your arrest. So you're in a very manageable spot. Just please be careful out on the roadway, because I know that while you don't have any convictions as a criminal history, your driving record is not a work of art, although you do have a valid driver's license. But the speeding is actually something that concerns the court as well. Obviously, Mr. Schreeman, we got a not responsible plea on that too. So those are your conditions. Do you have any questions for the court or your attorney?
No.
All right, you're all set. Get back to work and just stay on the path and look out for Mr. Schreeman. Good luck to you.
So do I call this number today?
Call them within 24 hours, so before lunch tomorrow.
Okay.
They won't
Good
hit
luck
the
to
order
you.
yet right now, though. So at least if you're going to call them, wait until after lunch today, maybe around 2 or later.
Okay.
Okay.
She's a star pupil. Mr.
She
Schreeman.
is.
All right, good luck to you.
Thank you.
Except perhaps where it comes to driving, where Magistrate Urich pointed out that her driving is, quote, not a work of art. Good morning, everybody. Happy Tuesday to you. Ellie is also here to say good morning. Yes, love up on your friends, sweetheart. Good. She's been waiting for all of you this morning rather impatiently. Welcome to TCF Live. Let's go to Judge McNally.
Go against it, Vasilios G.
Ready, Your Honor.
713-422. Somebody sent me what they call the victim's impact statement. And they said they were going to be in court.
They are, Your Honor.
Who is it?
It's Karen right here.
She shouldn't be, I mean, go ahead and state your appearance.
Sure. Good morning. May it please the court. My name is Matt Savage. I represent Vasilios G, who stands to my right.
Mhm.
Name is Vasilios G.
She's almost, did you read this statement?
I did, Your Honor.
The only reason I'm saying this is she's almost incriminating herself for filing a false police report. I don't want her to come up here and start saying things on the record. So, I mean,
I agree with you, Your Honor. I felt the same way. If I would have known that was being submitted beforehand, I might have.
I'm reading this thing and I'm saying, first of all, she's not a victim.
Right.
At least there was no charge filed against Mr. Grias versus her. And then I'm saying she is completely incriminating herself.
Right.
And I don't want to be a party to that. I shouldn't be a party to that. So I'm just going to pass along here. She doesn't have the right to speak anyway.
Right.
I'm going to ask you, first of all, but I'm not real excited about Mr. Grias's behavior here. Okay? I got an officer in a report saying he punched him in the face. So I'm just telling you, we got a problem here. I don't care if she called and should have, or should have called and called. We don't hit police officers in the face.
Your Honor, I agree. And we had this conversation when we put the plea on the record. You were disappointed then in regards to the.
I'm not disappointed now. I'm uptight about it because we don't have the right. We don't have the right, Mr. Grias. I don't care who you think you are, to hit people for doing their job. We don't have the right to do that. If you don't like what I do, you're going to come up here and punch me? I don't blame you for being quiet. You had a chance to review the report, and are there any material additions, corrections, or deletions?
I have, Your Honor. There is just one correction, which is the defendant's statement. That statement was actually not submitted by my client. He does desire to allocute. He has the written statement that he's probably going to read to the court because doesn't do public speaking and he's never written
It's fine.
statement before. Judge, the rest of the report is accurate, so there's really no deletions to make to it. I would ask the court to one, just strike the defendant's statement and actually withdraw that statement that was submitted.
Hey, I guess I'm not following. He didn't write a statement here, did he?
Well, what he
All I got
did-
is a blank version of offense. Is that what you're talking about?
Well, no, they've stated that there's a statement attached provided by the defendant. He did not provide a statement. He has it with him today.
Okay, I got you. I was confused by that too. Okay,
So that would be the only correction.
Okay.
Your Honor, I have a very short allocution. I know you've heard what I stated the last time we were here at the pre-trial in regards to me knowing Vasilios for, I think it's almost 18 years now. His daughter's in the courtroom. His son's in the courtroom. I think his son's wife is in the courtroom. His daughter, who's all at the left, her name is Abby. And my daughter and her played hockey together for 18 years. They played Beltire, Temporarily. They competed against each other in college. They play on the same team now. So I've known this family for 18 years. And I'm honored to say that they're friends of mine. You know, Vasilios may have some anger issues, but in terms of actually physically using any aggression towards anybody, I would like to state for the record, Judge, I reviewed the body cam footage 10 times. They were incidental hits. He got tased, and when they were pushing him down and arresting him, there was some flailing done. He never closed his fist and punched anybody intentionally. I have it on my phone if the court would like to review it. I'm letting you know as an officer of the court. You know I've been in front of you since 1994, since you've been on the bench. He did not physically attack anybody. No police officer, no one. And you could read that statement that was submitted. There's limited contact there. I think once you hear his allocution, reading his statement, I think you'll get a better picture of what type of individual he is. I know looking at the report, I've read it, the officer said he was punched. I'm not seeing that. He still committed the crime of resisting arrest. We're not denying that. But his behavior was belligerent and he was just avoiding getting arrested. It's essentially what he was doing. He was holding his.
let me see that video. Do you have it when they were on the stairs?
Yes, Your Honor, may I approach?
Yeah. Is there a way we can put that on the screen here, Lisa? Do you?
Judge, what I did was I just videotaped it off of my computer because
That's
I'm not
fine.
tech savvy, but
If he sends it to me by email, I can screen share.
Yeah, let's do that.
okay.
Then
Now you're asking a lot, Judge. All right, give me 1 second.
no, that's okay. It's going to be lisa@33court.com. LISA@33court.com.
While the attorney learns how to email Barbara, Ellie thanks you for the $5 for her Trito fund. We appreciate that.
I mean, there've been charges he's had. He's never had anything since 1980 that he was convicted of. I'll grant you that. He had an OWI and 2 domestic that were dismissed.
Correct. It downloading, Judge. I apologize.
Take your time.
So, Lisa,
At 33court.com.
you might want to have her watch it first before she puts it up, just in case, some video of me playing hockey comes up, that would be awful to watch.
Not as bad as my golf game.
I don't have it yet, Judge. I'm still waiting.
Lisa, I apologize.
Let me do this. You go down and talk to her.
Okay.
I'm gonna pass this case. I'll go on to another one. And when you have that all ready to go, Lisa, just let us know if you would, please.
Perfect.
Thanks.
Okay.
Hill, Samuel Lee Hill, 25W727451.
Good morning, Your Honor.
Your name?
Samuel Lee Hill.
Is this Miss?
This is Burns.
I'm gonna need her in here.
John Wayne.
Good morning. Your name?
Morning, Ron. As on behalf of people, PA 893.
So I just want to make sure I understand. He did everything, but he picked up a new charge for transporting a female for prostitution.
Judge, that is technically violating. I would say I would leave it to your discretion. I do know that it's not an assaultive charge he did. But I did also speak to the witness in the case. The witness was his mother on the case.
The victim.
The victim on the case, yes. It's his mother. She's okay with it being dismissed. She said everything's been good at home, so I will leave that to your discretion.
I just don't feel comfortable. I'm gonna get him a lawyer. What I'm going to do is I'm going to adjourn the review hearing. Let's see here. Let's call in the probation officer here, which is Jessica.
It's just weird. You're going to go wherever.
No, I'm gonna have them call.
He came in and talked to me about it as well.
Okay. Lisa, I'm gonna need a date 4 weeks out, which I'm gonna say should be September the 22nd. Let's go until.
Did you say 4 weeks?
Well, what I want
That
to
would-
do is, no, I'm sorry. I want to adjourn it out. I'm going to extend this probation for 2 months is what I'm going to do until September 28th. And then I'm going to set a new review hearing September 22nd.
He's answering probation.
At 8:30. Well, they might.
I'm trying to call everybody.
So that's what I'll do. Nobody's there.
No one answered. I called 3 different people.
Okay.
Thank you.
That's what I'm gonna do. So I'm gonna give you a new review hearing date. I will get a lawyer for you when you come back here. So Lisa, I want to make sure we appoint him an attorney when he appears for review hearing date. Sir, if you're convicted of a misdemeanor or a felony of any kind, then I'm sorry, I'm gonna have to enter the conviction and resentence. It doesn't necessarily mean jail. The conviction, I cannot dismiss that case with another charge pending. Okay? So that's what I'm doing. You understand?
No, could you like?
Yeah, one of the main provision was not to violate a law. Sir, can you keep your voice down over there, please? Thank you. One of the provisions was you're not to violate a law. Somebody thinks you violated a law. So I'm going to adjourn this case pending the outcome of that case to determine whether or not I'm going to enter the conviction on the basis that you violated the law. And I will do that. You can tell whoever's representing you on that case that the judge here is putting this off on the domestic pending the outcome of the case in Oakland County. Okay? You'll come back on September 22nd at 8:30. I will get a lawyer for you. You can go down the hall, get your notice, and we'll go from there. Any questions? Okay, you're all set. Thank you.
So I can't easily rewind here in the bunker without affecting the show, but if somebody out there could backtrack and make sure we heard that correctly, it sounds like Mom is the prostitute, if I heard it correctly. But I'd just like confirmation of that, please. Thank you.
Would you like an attorney to represent you? Okay, I'll go ahead and arraign you and then I'll send you to the prosecutor. It is alleged that you did on June the 23 of 26 operate a motor vehicle on I-75 northbound near Woodruff and Brownstown at 11:58 a.m. And they think that you did not have a license. That is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. And then you have a speeding charge here of 1 to 5 over. That would be limited access, 0 points, but it would go on your record. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here today?
Yeah.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yeah.
All right. Yep, you still wish to waive your right to a lawyer.
Yeah.
I'm entering a not guilty plea. I'm setting this, I'm going to let you go talk to the prosecutor. I'm giving you a $500 personal bond. You didn't show up last time. You need to make sure you show up. You cannot leave the state without the consent of the court or violate a law, and you must appear in court as directed. Do you understand all that?
Yes.
So I'm going to send you to the prosecutor. He'll bring the file over, and you talk to her, see what you can work out. Okay?
Thank you.
Good luck. People against Christian Joel Venancio. This is 26I 715-434 FYs, 26B 714-758 FY.
Good morning, Your Honor. Scott Weinberg, P45874 on behalf of Mr. Venancio.
Where is
he's
Mr.
on-
Venancio?
I think I see his family picture, but I think he's got to put his video on, Judge.
Are you Mr. Venancio?
He's on Zoom, Judge. He just doesn't have his video on yet.
Do you guys see
There
me?
he is.
Your name?
Christian Venancio?
What do you want? You want an adjournment? Is that all I
Your
got to
Honor-
worry about?
That's correct, Judge. Judge, just so you know, this is set for an exam next week. It's specially assigned prosecutor. They're two different cases, and my
Where's the
client is being,
prosecutor at?
well, the one I just dealt with is down the hall from you, but Madeline, hold on, Madeline, just got to remember her last name. Morrow is the
Is she
specially assigned prosecutor, and she's not here. And we have, just so you know, Judge, we have a review with a psychologist for my client to be able to get the report to her. And so we are looking to adjourn the preliminary exam, and set a new PCC to see if we can't resolve this.
I want to make sure that she's available. Call in Ms. Osmaro, please, again. Is that who you know?
She's not there, Judge. She's not there, but
Well, who wrote
Madeline
this
Morrow.
up?
The prosecutor that's right down the hall from you, right in the court.
Well, I got
But-
two of them here. I got Ms. Osmaro and I got Ms. Alloway. I don't know who this, I'm assuming.
Judge,
this-
I put him in a breakout room with Miss S. Morrow.
Yeah.
It's Miss
okay.
Esmeralda. That's why I talked to Judge.
Why, so if there's a special prosecutor, why isn't the special prosecutor here, I guess is my question. I can't set dates.
I appreciate
And
that,
then
Judge.
have her tell me I can't do it. I don't
appreciate-
mind adjourning this out for a week or two, but I need to make sure she's available when I set the case. I mean,
I understand, Judge. She did talk to the special prosecutor. Maybe she gave her some dates.
Yes, gentlemen.
Your name?
People be 8493, and I did well, you know, if I'm standing in for.
Yeah, I know, but I need these special prosecutors here.
I,
How can I set a date when they're not here?
she is okay with any date, and I did call her on the phone, it's Madison Oral's case technically, and when we
As
first.
long as nobody's gonna tell me that I need to adjourn it again. As long as nobody's gonna tell me I need to adjourn it again.
Today,
I'm gonna adjourn it today, and I'm gonna adjourn the PCC for a week, and I'm gonna adjourn the exam for 3 weeks. But I wanna be clear, if she's gonna tell me I'm not available, I'm gonna end up dismissing the case.
I understand, Your Honor, she did let me know that the only day she could do was 8:10 to 8:15 because she'll be in trial. Is that really so in,
No, that's fine. So she can do it the 18th.
that should be fine.
Do you wanna confirm that with her?
I can give her a call, but she did say that 10 to 15 the days that she could.
That's fine. So go confirm that with her, will you please? So that's what I'll do. Mr. Venancio, you have the right to a probable cause conference within 14 days of the date of the arraignment. Your lawyer's asking for an adjournment. If I adjourn this probable cause conference, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, Your Honor.
You waive that right.
Yes, Your Honor.
Also, if I adjourn the preliminary exam for 3 weeks and I adjourn the probable cause conference for 1 week, since you have the right to a preliminary exam within 7 days of the probable cause conference, that means that preliminary exam would not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes, Your Honor.
Do you waive that right?
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
All right, so here's what I'll do.
Your Honor, before you pick that date, if I can, just because I'm out of town until the 18th, I'm out of the country. Could we just do the next week, the 25th?
Let me make sure she's good the 25th. I wish you would have said something when she was in here.
I tried to, but she said anytime's fine as long as it wasn't the 10th to the 15th because she has a trial that week.
John,
Yes.
do me a favor. Go tell her the 25th.
Awesome.
I'm adjourning the probable cause conference to August the 4th at 8:30. And then the preliminary exam, barring there being some unforeseen circumstance, to August the 25th.
So that should be fine.
She said that'll be fine.
So that should be.
So that's what I'll do. August 4th at 8:30. Preliminary exam will be August the 25th at 10. No adjournments, okay?
Thank you, Judge.
Anything
Your Honor.
else?
No, Your Honor.
All right. But you're not asking for a competency exam, right?
No, Your Honor.
Good enough. That's what we'll do. Have a good day. Thank you.
Thank you, Judge.
Thank you, Your Honor. You as well.
Wachowski. Where's Wachowski? Jacob Allen Wachowski, 25W70072. Is this somebody, one of these lawyers? Is this one of yours, gentlemen? Or not?
He's proper.
Why don't you
No,
have a
Judge.
seat right at the table there? Recalling Vasilios G, 26W713422FY. All right, Lisa, I'd like you to play that for me. I'm assuming we're all set. Mr. Savage, your name?
Again, for the record, may I please report, my name is Matt Savage and I represent Vasilios G.
Your name again, sir?
Vasilios G.
Can you play that for me?
Judge, I still don't have it.
Did you go down and work it out with her?
Yes, I did. I was coming back to tell you that for whatever reason, it's not transferring. I have it just copied on my phone. It's only 20 seconds if you'd like.
Let me see it. Pull it
Yeah,
up.
approach.
Yeah.
Sorry, Judge, I'm so not technical.
That's okay.
It's ridiculous.
Let me see.
Okay, so it'll just play over again. This is like the tail end. So take 1 second.
This is the end of the first.
Yeah. Right. It's gonna start over in 1 second. Trying to start over, just one. No, I guess for this. This is the rest. Hey. Sure. Yeah, watch it. Sure. Thank you. How my body,
It's all right, Vic.
which is definitely.
I mean, go ahead.
Okay. Thank you.
All right. We've already started the sentence.
Yeah.
There's no material additions, corrections, or deletions, except for the fact that it says see attached statement, and he didn't give it an attached statement.
That is correct.
He has something he wants to read.
Yes, Your Honor.
Go ahead, sir.
Thank you.
I spent a great deal of time reflecting on event June 6, 2026, on how to express my serious remorse. I take full responsibility for my actions and understand the seriousness of what occurred. I am deeply sorry for the conduct and for the impact that it has on everyone involved. I apologize to the officers that evening after the incidents. They were there to protect and serve. I made their job difficult, dangerous, and the reason I want to apologize again. The experience I've had profound effect on both me and my family. I respectfully ask the court to allow me the opportunity to continue caring for those who depend on me. Help support my Oakley mother, whose health is declining, and I played an important role in their lives, my family, and my friends, and my significant other. They rely on me. I'm committed to continue for them to be, and I am committed to being a better role model. On July 27, 2020, my wife passed. Suddenly, unexpectedly, at the age of 58. Losing her was the most painful experience in my life. Loss continues to affect me every day. I do not offer me grief as an excuse for my actions. I have come to realize that emotional pain I carry since her passion has affected me in ways that I fully do not recognize. I now understand that I need professional help to process the grief and become a healthier, better version of myself. I'm fully committed to participating in counseling to better understand, manage my emotions and anger, and to ensure that the incident like this will never happen again. I do not want this single incident to define my character. Instead, I choose to review it in turning point, an opportunity for accountability, personal growth, meaningful change. And I sincerely apologize to everyone affected by this incident. I accept full responsibility for my actions and am committed to making lasting changes in my life.
Did you write that?
That's what I did.
Well done. Well done. Anything else?
No, no. Well, just simply asking the court to adopt a recommendation for conviction.
You did, it just appears to me that you did swing on the officer. Video's not that clear. You should have never done it. He's got some medical conditions. I don't know why they're recommending a psychiatric evaluation.
But just because he wants counseling. So.
He wants that?
Yeah, he wants it, he's gonna do.
Well, I mean, I want him to go to anger management.
Yes,
That's different than psychiatric evaluation, mental health treatment.
yeah, I don't think he needs psychiatric evaluation, but to just get individual counseling in addition to anger management, that's.
Is there anything that prevents him from doing the court work program?
Your Honor, I know his physical health is not the greatest, but do you think he can handle some physical community service, which would be manual labor, but not too harsh?
Will do anything I have to do.
I think he can handle that. He is on disability because he had a back.
I don't know. He's got some issues.
Yeah, he had a back,
All right.
that caused him to be on disability.
I don't want to press it. I'd feel horrible if something happened. What you did was wrong. I sense that you understand and recognize that. It was well written. I do sense that you have a lot of remorse. You've not had any conviction for 46 years. 15 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No firearms. We don't want you to possess firearms or dangerous weapons. You don't have any? Anger management program with 12-week follow-up. If you want counseling in addition to that, you can get it on your own. No contact with the victims, Cameron Pozlako or Tom Timmis. You cannot write, phone, see, text, email, or communicate with them in any form or fashion. $200 in fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $5 1/4, screening fees 60 for $585, probation fees are $300 for a total of $885. I think I said 15 months probation. I did say that. I'm also going to order 7 days jail credit, 1 serve 6. I'll let you serve those by way of community service. So 48 hours of community service, and I'm going to give you until, let's see, this is July 28th. I'll give you until September the 30th to complete your 48 hours. You may be eligible for early discharge pursuant to statute. You've done everything and there's no violations within the preceding 90 days in 7.5 months. You can come in here and seek early discharge. If you violate, your probation could be revoked. You could be incarcerated for 1 year, 365 days with credit for any time served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Well, I sense that he's remorseful. That's a good thing. I don't see that a ton. Okay, that's what we'll do. Can he pay this today or does he need time? I suspect he needs some time.
You can pay the $585 to them, then.
Well, it's probation fees too, $300, $885.
Pay them monthly, so you can.
You just tell me what he can pay today.
You can pay the $585 and finding costs, and then it's better making payments for.
I'll just make it $40 a month then, okay? $585 today, $40 monthly, and I'll start that beginning September 1.
Perfect.
If something happens and you need more time, you call the court, we'll go on Zoom. I'll give you an extension, or you can come into court and I'll be glad to give you an extension, okay? But it has to be on or before the due date, 8:30. Just don't ignore me, all right?
Thank you, Your Honor.
Thank you.
I wish you well. Thank you. Good luck. You'll meet with probation before you leave. Thanks, Mr. Savage. Have a great day.
Once again, good morning, everybody. It is TCF Live on a Wednesday. Barbara sent me $10 on Cash App, says, "You're the best host on YouTube." Thank you, Barbara. I appreciate that very much. We do have Venmo and Cash App if you are so inclined. We are at TCF Live on Venmo and $ TCF Live over on Cash App. Nobody is obligated, of course, but your support is appreciated. Let's do this. Let's go to Florida. Wade Mercer.
Being here, both of us, Corporal?
Yes, Your Honor.
Perfect. First case is Jacob Smith.
Mr. Smith?
Mr. Smith, good morning. You're here because you've got a failure to appear in case number 26-272 the charge is battery. I believe this is a case that you were first appeared on, set a bond, posted bond, and then missed your court date. So that's why you're here. Listen to Mr. McDaniel. I'm appointing his office to represent you, and he's going to tell us when your next court date is going to be. Mr. McDaniel.
Just put him on the August 12th arraignment docket, Your Honor. Jail
Mr.
arraignment.
Mitchell. Thank you.
Yeah, nothing, Your Honor.
Mr. Smith, do you have any questions? All right, we'll see you August 12th, and we'll see where this thing goes then. Have a good day, sir. Let me see Patrick Smith next.
Patrick and Christina.
Now, we got Patrick Smith, and I've got two different names. I've got Christina Bills, but the warrant is under Christina, different last name, I believe.
They're married. Her name's changed. She just hadn't changed it on the driver's license yet, but
Okay.
it's changed on the social security card, but it's Katrina Smith.
Okay, thank you. So both of you, I'm seeking at the same time because your cases are identical for our purposes this morning. Ms. Bills, Ms. Smith, and Mr. Smith, you both have warrants out of Bay County. In neither case is there a bond on the warrant. That doesn't mean you're not going to get a bond. What it means is that the issuing judge put no bond until first appearance. I think I saw Judge Jeffcoat's signature on at least one of these. So you'll go to Bay County. That could happen today. More than likely, it'll be over the next several working days, 2 or 3 working days normally. When you get to Bay County, you'll go to a first appearance there. That judge at first appearance will decide if you're entitled to a bond, and he or she will then set you a bond if they feel like you're entitled to one. Let me see if either of you has any questions. Mr. Smith, do you have any questions? Mr. Smith, do you have any questions?
No, sir.
Have a good day, sir. Ma'am, do you have any questions?
No, sir.
All right, have a good day, ma'am. Benjamin Cross.
Hey, y'all come on, man.
Cross, good morning. Mr. Cross, you're here also on the failure to appear. Yours is for a charge of, well, I think one of these charges were dismissed by the state. I'm not sure which one. I think it's the operating a motorcycle without a license is, well, actually, there are 2 charges. There a third charge that was dismissed? Don't look at that case. Give me a second to look at that case. I thought I saw something that had been dismissed. 26. There may have been 3 charges originally. I don't know. Could be wrong.
There may have been an agreement to dismiss one.
No, one of the cases I saw this morning, there's actually no information filed, but it was only as to 1 count, but it may not have been Mr. Cross. It may have been another case I was looking at. Yep, it wasn't this case. So you've got 1 charge of driving a motorcycle with no license and 1 charge of no motor vehicle registration. I'm appointing the public defender's office to represent you. Please listen to Mr. McDaniel, your attorney, sir.
Your Honor, I spoke to Mr. Cross. He's going to plead no contest to the charges as listed. Understanding 10 days in county jail, 3 days jail credit, and purge the remaining of his sentence by paying $400. He has signed his plea waiver form, waive his right to jury trial, and call witnesses that'll resolve this case.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Cross, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
No, sir.
Is that the plea you would like to enter?
Yes, sir.
Mr. Cross, I'm going to accept that plea of no contest to these 2 charges. Judge, you're guilty of those offenses, sentence you to 10 days in jail, 3 days credit, but you can purge the sentence at any time before you complete it by paying the court costs and fines in count 1, which is $400. I'm going to waive the court costs and fines in count 2. So if you pay that today, you'll be released today. If you pay it tomorrow, you'll be released tomorrow. If you finish the 10 days and haven't paid it, you'll be released at that point. Mr. Cross, you will get to use the phone in just a few minutes, sir, to contact friends or family to try to post that, purge them out, and get this matter over with and resolved. Do you have any questions?
No, sir.
Yeah, one more thing. That purge amount, thank you, Mr. Gibson, that purge amount is paid at the clerk's office. So here's why I'm telling you that. If you contact friends or family and they show up with $400 at the jail today, they're not going to get out till tomorrow. they've got to pay it at the clerk's office, and you also need to know the clerk's office is open till 4:30 p.m.
Okay.
So if you call somebody and they're going to pay it, tell them they got to get to the clerk's office by 4:30 p.m. so that you will get out today, which is what everybody hopes happens. Any other questions?
No, sir.
Have a good day, sir.
Yes, sir. Thank you, sir.
Yes, sir.
Yes, sir.
Mr. McDaniel, that's everything I had on my list this morning. Anything else from the public defender's office?
No, Your Honor.
Thank you, Mr. Mitchell.
Nothing from the state, Your Honor.
Corporal, anything else?
It's a short morning for Judge Mercer. Let's go back up to Judge McNally. I've got a few other judges I've got my eyes on, but they really don't have anything rolling yet. So we'll go back to Judge McNally.
You've been sitting there, Mr. Holmberg, and what do you have? Did you talk to the prosecutor?
I did, Your Honor. We have Mr. LaBelle. We're just asking for the exam to be set for next week, as I think you already scheduled at 10:15, and he's here.
File on LaBelle. All right, she's gonna get it together there, and we'll, people against Jacob Allen Wachowski, 25W700782FY. Come on up here. Your name?
Jacob Wachowski.
You've been drinking today, huh?
Not today.
You didn't violate any bond, you didn't violate any sentence, probationary terms and conditions, but I don't want you to, we're gonna give you a PBT, okay?
I'm not sure what it is.
Machine you're gonna go blow into. I'm gonna find out if you've been drinking or not. Okay, you didn't drive here, right? You didn't drive here, right? Who drove you here?
A friend of mine.
Where's your friend?
She had already left.
They already leave. That's always what I get. They drop you off and leave. John, have them administer the PBT and we'll see what else they do. Okay, thank you. All right.
Here's the bell.
All right, people against, Aaron Raymond LaBelle, 26F703624. This is gonna go to exam?
Yes, Your Honor.
Your appearance?
Yes, Your Honor. Edward Holmberg on behalf of the defendant. And Mr.
Where's
LaBelle, say
Mr.
your name?
LaBelle at?
Right here, Aaron Raymond LaBelle.
Your name? Okay, so we're gonna go to, I don't know what she wrote here, keep PC.
I think she meant kept exam date because the subpoenas already went out for the police officers.
All right, so preliminary exam will continue next week. Preliminary exam will be August the 4th. And that will be at 10:30 in the morning. Is that right, Lisa?
That's correct.
Okay, so that's what we'll do. I'll see you next week. Anything else?
That's it, Your Honor. Thank you so much. Have a good day.
Thank you. You too. All right. She's processing those. Just give us a second, guys and ladies.
The informal is ready too, if he hasn't put that up yet.
There's an informal I'm gonna do?
Yes.
I mean, it's actually a hearing?
Well, I don't know. They're on Zoom.
Who's got that informal?
Just the troopers here. I'm not sure if the defendant's in person.
I see. All right. Pauline Mel Ghazali, 26D 241826. I like this, the way they wrote this. Come on up here. Your name? This is the fishing license case. They say the defendant has license dismissed in the interest of justice. Case dismissed. Good luck. People against Ali Nasser? Ali Nasser, 26D 242053. Where's Ali Nasser? There you are. Come on in here, please. Mr. Nasser, you got to start your video and state your name, please. There you go.
Hello, Your Honor.
Your name?
Ali Nasser.
Says you have a license dismissed in the interest of justice. Case dismissed. You're all set. Banu?
Yep. Thank you so much.
Aditya Banu, 26M688869. Mr. McCandless?
Morning, Your Honor. Glenn McCandless, behalf of Mr. Banu.
Is this really going to go
Well, probably. I mean, we might work it out beforehand, but you know, the officer might or might not show. I don't know. Who knows?
Didn't they offer you anything?
They don't offer anything on these truck tickets anymore, Your Honor. And you know, this one here, I think was
I didn't realize. Okay, I see.
improper lane, the third lane for the exit. So there's
I
a
got it.
defense, you know. So
I got it. All
and
right.
nowadays, I think they're writing them, and sometimes they don't appear on these, or they let you know that they're not going to appear on it ahead of time. I don't know. I mean, I don't know what's going to happen, so we just have to set it for
Just going
formal.
to set it for hearing next week. At what time, Lisa?
9:30.
At 9:30. Good with you?
What day would that be, Judge? I'm sorry.
August the 4th.
August the 4th. Is that in person?
Yeah.
Ooh.
I can make it later. 10:30.
Actually, earlier is probably, but
You want to make it earlier?
yeah, I think that earlier is probably gonna be it. I got
Make it at 8:30. How's that?
8:30 a.m. That's perfect. August 4th.
All right. So this will be in person next week, August 4th.
Okay.
And you're going to have your client, right?
I should have them on Zoom or live. These guys are out of Canada.
He's out of Canada. I don't
yeah.
mind if he appears by Zoom.
Okay, thank you.
In person, but defendant can appear by Zoom.
Okay, thank you.
All right.
And then-
See you next week. How you
Judge,
doing,
I have
Mr.
another one
Camus?
for
All right.
Michael. I have another case, Michael Frames. Same thing, truck driver.
Yep, I got that one. Michael Frames, 26M, 705-795.
Glenn Camus to be up, Mr. Frames. Judge, we're asking to set that matter for formal. August
We'll
4th
just
at
adjourn
8:30.
this for a formal. That'll be August the 4th at 8:30.
Okay.
Attorney in person. Where's defendant from?
He is from Toledo, apparently.
I don't care. He can appear by Zoom if you want.
Okay.
If he wants to appear here,
Yeah.
I just need you here, okay?
Okay,
You're all
thank you.
set.
Have a good day.
Thank you.
Have a nice day. Nice seeing you.
Bye now. Sherrell Bianca Benson. 26X-472-3703. Trooper, or what do I have here? Trooper Bayer. Is he out there?
Yep. He's coming in right now.
Good morning, Trooper. Your name?
Morning, Your Honor. Trooper Buyer.
You're a winner today. The defendant failed to appear. Case default judgment. Case was scheduled for 9. It's now 9:28. The defendant failed to appear. I think I got another one of yours maybe here. Oh,
Yeah,
wait
I
a
got
minute.
2 today.
We're having video or audio equipment difficulties here. All right, Nicholas Anthony Jones. Did you get that last one, by the way? Did you get the last one?
No.
Okay, so I got to call that one. Wait 1 second. Stay right there. Sherrell Bianca Benson. We had recording equipment difficulties, so I'm going to call this one again and put on record. 26M-723-703. She's not here. Your appearance again, Trooper.
Yes, Your Honor. Trooper Buyer.
I'm going to go ahead and enter a default judgment here. Defendant failed to appear. Thank you. People against Nicholas Anthony Jones.
Good morning, Your Honor.
26M-724-888, A and B. All right. Your name, Trooper?
Yes, Trooper Buyer.
He doesn't have a very good record at all. Did you see it?
I did. I believe there was 4 prior speeds.
I accept responsibility. I really wish there would be no points.
Well, I can't do that when you drive like a maniac. I'm sorry. You can't do that. I mean, I can't go home and look in the mirror when I start giving out impedings with records like this. I mean, what do you want to do on this, Trooper?
If cutting it down to like a 6 to 10 limited access is something he's interested in, I'm fine with that.
What about the expired plate?
I do have.
As long as he took care of it, I'm fine with that being dismissed.
What, do you have any problem with dismissing that?
I do not.
So if you plead to 80 and a 70, he's going to dismiss the 16 to 20 over. There's 1 point, and this will go on your record, and then he's going to dismiss the expired plate. To that charge, 80 and a 70, responsible or not responsible? You got to slow down. Jeez.
Yes.
All right, so I'll accept the plea 175 and dismiss the expired plate. You can go down the hall and pay on the speeding, okay?
Thank you.
Slow down, please. Good luck. Thanks, Trooper. Do you have any more?
That's it, Your Honor. Thank you.
Have a great day.
You too.
Jacob Allen Bukowski, 25W700782.1. I need to get him a lawyer right now, John. Who's our
Graziano.
call him Mr. Graziano.
What's the answer today, Judge?
I got it. Seat right at the table behind me, okay?
I'll go try to find it.
Right there, sir. Snurling, Kenzie Marie Snurling, 23G722104FY.
Morning, Your Honor. Michael Piechnik here on behalf of Ms. Snurling.
OIC is now chief. What does that mean?
We're missing some digital discovery. The prosecutor emailed the officer in charge, but the officer, this is a 2022 incident, and that officer has been promoted to chief of police. So she anticipates.
Okay. All right, I got it. Where is Mr. Snurling in?
Ms. Snurling is on Zoom. Ms. Snurling, will you unmute?
My apologies. Your name, ma'am?
It's Kenzie Snurling.
So this is what I'll do. Ma'am, your lawyer needs an adjournment so they can get him the materials, so the discovery. So I'm willing to adjourn this PCC for 1 week and then the preliminary exam for 3 weeks. So we would make it August the 4th and August the 18th. Was that good with you, counsel?
What time on the 18th is the exam? I have an exam set at 11 already in a different court.
Correct.
Let me look it up really quick, Megan.
Ma'am, if I grant his request to adjourn, the probable cause conference will not take place within 14 days of the date of the arraignment. You have the right to have the probable cause conference within 14 days of the date of the arraignment. Do you waive that right?
Yes.
And if I adjourn the exam until the 18th, that means the preliminary exam will not take place within 7 days of the date of the arraignment. Do you waive that right? The date of the probable cause conference. Do you waive that right?
Yes, sir.
All right. Counsel, what do you want to do on the 18th? I don't really want to adjourn it. I can call them in and do it at 1 for you if you want. What court are you in?
Judge, I'm with Judge Zelnick in 25th District, so Lincoln Park. So
and that's at 11?
That's at 11, sir, yes.
Well, let's do this at 9:30. How's that? Is that okay, Lisa?
Did you say 11?
No, at 9:30 on the 18th.
Oh, you're pretty loaded up on the 18th with informals and pre-formals because you're off on the 11th.
Do you think
Can we
this
do
is
the
going to
afternoon?
go? Do you think this is going to go?
I do, Judge, because it's if they're without having to really relitigate. It's from 2022. Her name doesn't appear anywhere in the discovery so far that I've gotten. It's very
Okay, let's still go with the 9:30 exam, okay? So that's what
Yes.
we'll do. And I'll get you here. You show up at 9:30 and we'll have you here, okay? So we'll
Thank
see
you,
you
Jeff.
next week, first of all, August the 4th at 8:30 and then August 18th at 9:30, okay? And that'll be in person, obviously, the exam. Jacob Allen with
Alrighty, friends, about to enter hour 2 of TCF Live. Let's change it up a little bit. We'll stay in Michigan, but let's say good morning to Judge Oakley.
It should be sitting at passage.
Aiken?
No.
Miller, you said. Tell her to start putting her name at the top of the plea agreement, then I'll know who she is.
Oh, I was.
Good morning, counsel. Your appearance for Miss Miller. Thank you.
Your Honor, I'm happy to tell you we have an actual result this matter today. Ms. Miller is going to plead guilty to this charge. No, that is from person.
All right. Miss Miller, did you discuss your rights and options with your attorney? Did you understand your rights and the options those rights give you today? Do you understand the possible penalty for no valid operator's license? Are you pleading guilty to that charge freely and voluntarily today? Did you drive a vehicle at or near the airport on March 13, 2024? And at that time, was your license suspended, revoked, or denied? I will accept your plea to the added charge, dismiss the original charge. What should I know before I sentence Miss Miller?
Your Honor, unfortunately, there is no driving record in the file, but I have explained to Ms. Miller how to go to the Secretary of State.
Good.
Get her driving record, figure out what she's got out there. I do know that the court file here contains a no proof of insurance from, I think, 2021. I'm
Yep.
sure that's keeping her from having a valid.
Yep. Yep.
And she does have my number,
Okay.
so if you have any questions, I will help you figure it out. Because driver's license records aren't the easiest things to.
Are you working?
Yes, I just got into a job in a nursing home.
Good. Good, good. Full time? Okay. Got a lot of stuff you owe money on.
She owes this court a ton.
You owe anybody else? Any other courts?
I just don't know where.
Have you ever had a ticket in Livonia? Okay, I'll check it out because Livonia just sent us an email that says they're doing an amnesty program. So, yeah, Avery's supposed to be posting notices around our building today. So, check and see if you owe them money. Now's the time to go see them because you might be able to get out without late fees and penalties. Okay. When's the last time you worked? Have you been off work for a while?
No, I'm working right now. I've been working at this nursing home for a year.
Oh, okay. Okay. I had the impression it was a new job. All right. So one of the things you can do on the $2,000 that you owe us, I haven't sentenced you on this one. We'll get to this one. On the $2,000 you already owe us, if you go down and talk at the front counter, talk to Mr. Taylor about payment options, we might be able to do some kind of a deal where you do some community service hours and pay some money and we're taking care of your debt quicker. Okay. But I need you to do something, put a plan in place. So when you walk out of here, we know what your intentions are on that $2,000. Okay. All right. Anything before I sentence today? Did he swallow a fly or something? All right, let's see. All right, I'm going to waive some late fees on this. You got $100 worth of show cost fees and $50 worth of warrant costs. I'm not going to hit you with those. Find your costs on the file, $500, and I'm ordering 4 days on the core work program. The work program, let me go back. The $500, add that into your $2,000 that you owe, and then you can work some kind of a deal on everything. Okay? The work program, we assess work program as an alternative to jail. We run the program 7 days a week. You pick which days you want to work. The days you pick, you got to be here at 8 o'clock in the morning. Questions? All right, good luck with your license. And when she offered to help you with your license, take her up on it. If you get your driving record and you don't know what it means, let her know.
Go down and see Mr. Taylor. Mr. Taylor, Your Honor.
Yep.
Alrighty, friends, let's head down to Texas. Judge Stevens is getting his day rolling. We'll check in with him.
Okay.
You're Ismael Rio. You're here with Mr. Burbank, your attorney and the state's attorney. Put it on trial.
We can, Judge. I've been kind of talking to the prosecutor. It's not Mr. Ham. I believe it's Mr. Hill. I know it's Mr. We can put it on the trial docket if you'd like, but it should be resolved.
It's going to be resolved.
Either way.
One way or another.
Yeah.
The defendant, I guess you talked to him about not having any contact.
He does, Judge.
Are they together again?
No, they do. He does still support, and because there's a house and there's kids, he's got another place to live. When there is back and forth with money so that the family stays in where they're at.
We'll just, I guess, put it on the trial docket and see what happens. I guess. Is that okay? Or what do you
Yeah, that's fine, Judge. If we can get it worked out before, there were some documents and the complaint and stuff like that.
When's our trial docket next that you're setting it to? You don't know yet?
November.
See, that's a half a year away. I mean,
That's fine, Judge.
Is that what you want to do?
Not really.
What do you want to do?
Give me 30 days.
Yeah.
Maybe as soon as Mr.
All right, let's read the said for 4 weeks. Okay, for
That'd be
the
good.
announcement. Thanks.
He'd like to get it taken care of.
All right. Well, get a resetting. Thank you.
And I'll give you a call. since I told the prosecutor.
Etta Pearl Stelling.
Yes.
Etta
Stelling.
Just keep on coming, yeah. Huh?
Oh, dear.
What do you want to do?
Your Honor, this is all based on DNA. We need to know what the sample or what the testing comes back at. This is a tragic accident where the dog was hit on Major Drive, and I guess the owner ran out also at night. And also was killed.
Okay. I'm just looking at the probable cause, just as a side. The defendant stated she hit the dog because she didn't hit the person.
Right.
And according to witnesses, she was holding the dog when the dog was hit.
She never.
So, well, that's what witnesses say. I guess that's going to be the issue.
Probably the issue and.
So what do you want to do? Put it at trial?
We have to wait for the DNA. Once we find out what the DNA is, then we may be able to move it.
How would that be?
Well, we gotta know what's underneath the car, whether or not it was the animal or was it you.
Okay, the DNA was from swabs on the car? Okay. 4 weeks, see where it is, but it may take longer than that.
I don't know who.
When did this happen, April?
Now.
This is Kanisha's case now, and we'll do some follow-up to see where it's at, Judge.
Well, let's review it in 4 weeks.
That's fine.
All right, thanks. Okay. Get a resetting.
Sign that, not talk about it.
John, yes, John Kenita.
Just can we hold on a minute? It's
Yes, sir.
a dismissal for restitution. She's down at the bank getting a cashier.
Okay.
Now.
Dante G.
Call this name, I'm sure.
There's got 4 cases here.
Yep.
It's gonna be a windfall on bond. Okay. 1, 2, 3, 4. Okay. 26 CR 963, 26 CR 964, 26 CR 965, and you guessed it, 26 CR 966, all the state of Texas versus Dante R. Grant, charged with the 3rd-degree felony as obstruction or retaliation, 2nd-degree felony assault on a peace officer.
This man is just walking up. Are you Dante?
Hold on, sir. 3rd-degree felony of harassment of public servant, and to round out the field, 3rd-degree felony harassment of a public servant. So you're looking at a total of up to 50 years in prison in all these allegations. Mr. Dusler?
I've never met him till
there he is.
1 second ago. So if we could hold on an announcement, I'll visit with him, get back with him.
I'm thinking out loud. Got a safety report. Trying to look at. Does the state have something?
I'm not this judge of it. Didn't know you were headed that way.
I don't have it on here. It just curious. Have you been living in Beaumont your whole life?
Yes, sir.
Yes, sir. Okay. Can you pull up Mr. Grant, see if there's anything? All of this happened in the same event, is that right? Look like
all these come out of the same event, yes, right.
They carved out 4 cases out of that.
According to our NCIC, it's a total of 3 arrests.
Other than this?
No, I'm reciting to you what's in here, Judge. It would be inclusive of the state.
Oh.
So 2 additional arrest dates. Most of those appear to be misdemeanors, Judge.
That's my prior felonies that I see in Jonah.
What do you have?
Some prior misdemeanors, failure to ID.
Or you said no felonies?
Correct.
Oh.
There's no prior felonies.
What's the misdemeanors?
Failure to ID.
Resisting arrest.
What happened on the resisting?
That's the same thing. It all
Hold on.
happens.
Hold on. We're gonna look at something.
No.
And you need to talk to your lawyer before you say something, because yesterday somebody got in big trouble from making some statements when his lawyer was trying to tell him, don't say anything.
The resisting arrest is still pending.
Yes, that looks to.
Okay, so he doesn't have any convictions?
No, sir. He has, other than the failure to ID, he has no convictions for a felony offense.
Right.
And that misdemeanor resulted in 20 days, Judge. He had a prior felony that was brought down to class F.
Okay. And what we're gonna do is reset it down how much time?
Normal.
This is the criminal district court. There is no normal.
4 weeks.
There is no normalcy. 4 weeks good for you?
That's fine.
Okay, I want you to get a resetting and then have a seat right over there before you leave. We're gonna test you to make sure there's nothing odd in your system.
Right.
And that's Mr. Grant had 4 cases. That way.
So I reset. Yes.
Kenneth Hicks.
Yeah, I called his name. I had patients.
26 CR 1020. The state of Texas versus Kenneth Earl Hicks. There is no answer here in the courtroom. I ask the bailiff to call into the hall for Kenneth Earl Hicks, please. Thank you.
I share sheets and that's right.
I don't need don't do believe after we finish it.
You've got, she's off of probation.
I don't need to stay jail.
You didn't talk to him, did you?
I shut him off.
I don't think he's here.
Probably 5.
Okay, thank you.
No response, John.
No response to the name called here in the courtroom. No response to that name called into the hall. Defendant has failed to appear. Warrant shall be issued for his arrest. Is it $7,500? $7,500. His bond is revoked. A warrant shall be issued for his arrest. It is now doubled to $15,000, plus the defendant must have a GPS device and will be at home confinement, except for the exceptions the court gives, and that's to and from work, to and from lawyer, to and from court, to and from food in the most direct routes possible. And he must again have a GPS device. The orders of the court, and the warrant shall be issued. I have Darrell Lewis. That's been reset.
I don't know. Did
Defendant is
someone hire someone?
no defendant's not feeling well. That's what I have here.
I have no information.
Reset 1 week.
Never spoke.
Defense. All right, Noah Niemeyer.
He's here to go.
All right, you're Mr. Niemeyer, and you're here with Mr. Dusler. You have been indicted for the state jail felony of theft of materials, which is a state jail felony. But there are 2 other state jail felony convictions that are showing up out of Liberty County, 1 out of Liberty County in 2011, and 1 out of San Jacinto County, 2016. So if you were found guilty of this and all of these were proven true, then you're looking not at a state jail felony punishment. It would be a state jail felony, but because of your prior criminal history, if this is true, it would be punished as though it were a 3rd-degree felony. So you're looking at no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. Plus, if these convictions are valid, you're not eligible for probation in county jail. So there are some doors of opportunity that have been closed because of criminal history. That's the way it is. It's not a debate. That's just the way the law is.
Yes, sir. I understand.
All right. What are you going to do today, Don?
Guys, we have a situation where we have an offer on the table that's good for today only for the minimum, which is 2 years state jail.
Flat time?
I'm sorry, 2 years TDC. Yes, but he doesn't want to report right now because he's got temporary custody of his daughter. We were wondering if we could enter a plea of guilty today and then reset for sentencing at a later date.
That would be the state's preference, Judge. If he wants to accept that offer, that 2-year offer, I want to lock him in today if possible.
We don't have to have a PSI, but we
just taking care of the child.
I am right now.
Right now. Where's the mother?
The mother, about 2 months ago, was diagnosed with some
illness.
Sir.
Illness?
Yes.
Okay.
And so,
without you, who takes care of the child? If you
Well,
have to go to prison,
that would be something I have to figure out, Your Honor. I don't know.
Yeah.
Like,
you don't have close relatives who can,
I do, but my mother is.
you have to make arrangements.
Yes.
Well,
There's a 10-month.
Do that. You have time. I'll give you time. How much time do you think you need?
Well,
weeks.
Man,
What do you think?
Okay, well, this is the worst case scenario. She's on a 1-year therapy for this.
No.
Your mom?
The mother of my child. She's going through this.
Yes.
It's a year long and.
Okay, who's the backup to take care of?
I really don't have, my mother is, I'm 47, my mother's 82 years old, and I don't know how, I have a brother who's 37, but he doesn't have a kid, and I don't know.
You know, I mean, but.
And
you gotta, you know, the grand jury's indicted you and you're presumed innocent here, but you've got so many obligations here, familial, you got no business committing crimes. I'm just talking.
Yes.
I'm just lecturing like I'm your father kind of thing.
Right.
You don't, your children and your family are first, and whatever happens to you by your mistakes, and this is the third, if it's true, you got 2 prior convictions of controlled substances. Hopefully that's been beaten.
Oh, yes, sir. I'm clean as, I've been clean for a year and 3 days, July 27th of last year.
Good for you. But these things happen in 2000. You were
Right.
convicted a decade ago, and it took you a decade to get off of that stuff.
Well, yes. And it's terrible. It's a terrible disease.
Well, it's not like you pick it up from the flu. You made a conscious choice.
I did.
You know,
that's what my mother's told me is you decided now to do it.
Me too. We're all accountable for the choices we make, unless somebody put a gun to your head and then you're forced to. But you've got dependence, and drug usage is a selfish act.
It is.
And you're putting other things in front of what our Creator gave you as obligations. You don't get to pick your children. The Creator gives them to you, and then you make the most of God's work, not by standing in here in this courthouse with Don, who's a great lawyer, trying to figure out how to fix some of your mistakes. You got to fix them with the choices you make, and you're capable of this, and you've got good reasons to make good choices, and terrible, horrifying thoughts about the consequences you pay when you have to go to prison because of another crime when your children are left.
Yeah.
God, I can't even imagine, because I've got 2 and three little grandchildren now. So
I don't even know what happens if she can't be taken.
Well, I know.
I don't have.
I know, but let's jump ahead. There's a way to avoid all of these problems, right?
Stay.
Your choice that you make.
Yes, sir.
And put others first.
Yeah.
Especially your children. Anyway, what are you going to do?
Well, the question is, may we enter the plea today?
You can do that.
Set for single later date.
And we'll just do
Please, Jonah, please.
a pre-sentence report and see what happens.
We really don't even need that unless you just want it.
Stay with.
It doesn't matter. It doesn't matter whether you get one or not. It's really probation of law.
State.
Why don't we do one? Because I've got some ideas.
Okay.
Judge, I will say this, he's got history that someone is doing.
Now,
Other than what's listed.
I want to, you know what I want to know?
Other than what's
the full extent of what he's got, all of his problems.
I could tell you, Your Honor, if you wanted to really know, and I wouldn't lie to you. And they all revolve around drugs, but I am drug free.
For how long?
I got 1 year. July 27th of last year was my last day to do any substances.
How long were you using drugs?
I'm 47 years old.
How long?
25 years. I've been
a quarter of a century.
Quarter half my life.
How old are your children?
I have a 22-year-old, a 21-year-old, a 20-year-old, and a 10-year-old.
Your Honor, if I could jump in, please.
Hold on.
Yes, sir.
So you had children and after you had your children, after this 25 years total, you were on drugs, you have children, and you continued abusing children?
I was a tyrant. I mean, I've given it
I feel
up.
sorry for the kids.
I've given it up, Your Honor. Like I've changed. There's been
For the better or worse?
for the better.
Okay.
For the better.
Judge,
What's the offer here?
the minimum of 2 years, Judge. In the interest of judicial economy, Judge, I don't know that the PSI will show any more than this summary of criminal history.
But I appreciate your input. We're going to just take the plea, and then what do y'all want to come back?
Whenever the normal PSI time would, if you're already.
How long does it take?
Certainly.
What do we said? Yeah. We don't need a pre-sentence report, really.
I don't think so.
What's the resetting y'all want to come back with? 3 weeks?
That's
Is that good? All right. Yeah, 3 weeks to take care of your affairs. Okay.
3 weeks.
Don't plead.
I'm not, Your Honor, one thing I'm not going to do is run. 3 weeks. What if I can't do it in 3 weeks?
What do you mean?
What if I don't have it figured out in 3 weeks? I'm not running.
But nonetheless, this really isn't on your terms.
Right. No, I understand.
You're not running the show here.
No, I'm not.
Is 4 weeks better for you?
Yes.
Well, all right, we'll just do 4 weeks.
And I'll be in custody.
That's a normalcy from a plea to a sentence. And that gives people more than enough time to take care of their problems, which are long overdue to be taken care of.
Right.
Literally so.
I'll get him set up.
And then we'll do this plea here. Okay, thanks. That's Mr. Niemeyer.
Oh. We'll get you that.
Alrighty, good morning once again, everybody. It is TCF Live, hour 2 now on this Tuesday. Thank you to Michael Furberger for giving me a promotion to channel president. Appreciate that. Let's go up to Michigan, one of this channel's new favorites, Judge Aquilina.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. And Counsel, could you just aim that microphone toward him? Yeah. All right, thank you. You don't have to lean over it, just find it a little closer. All right. So are you taking any medication yesterday or today?
No, ma'am.
Are you supposed to be on any medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had an opportunity to speak with your attorney?
Yes, ma'am.
And so you pled no contest to accosting children for immoral purposes, punishable by 4 years, and criminal sexual conduct 4th degree by force or coercion, punishable by 2 years. You recall that?
Yes, ma'am.
You were placed on probation, and you were to be on probation for not less than 5 years. I gave you the 5 years. You also spent jail time, and then you were on probation. I have a bench warrant here, which is why you were arrested, that alleges as follows. On or about March 12, 2026, defendant had contact with minors at his residence. Count 2, at an unspecified date during the period of September 16, 2024 through May 28, 2026, defendant had contact with minors at this GED program. Count 3, at an unspecified date during the period of September 16, 2024 through May 28, 2026, defendant went to Six Flags over Georgia, a location where minors may be present. Count 4, on or about December 8, 2025 through December 11, 2025, defendant left the state of Georgia without permission. Count 5, from February 1st, 2026 through April 30th, 2026, defendant failed to attend 7 of his 12 mandatory sex offender treatment classes. Count 6, as of May 29th, 2026, defendant has failed to make any payment toward his court-ordered restitution. Are there any amendments?
Yes, Your Honor. As a result of a plea. Counts 2, 3, and 4 are to be dismissed. And no further amendments after that, Your Honor.
On behalf of the people, that is the agreement?
Yes, Your Honor.
On behalf of your client?
It is.
So we're dealing with essentially failure to pay costs or start toward restitution, having minors at his residence, and also failure to complete or attend and complete the sex offender treatment. Sir, do you understand the allegations against you?
Yes, ma'am.
You have a right to a hearing, you have a right to plead. I understand there's going to be a plea, is that correct?
Yes, ma'am.
Counsel, are you waiting for the arraignment?
We are.
All right. And sir, you understand I could revoke probation. I also could find you in contempt and send you to more jail.
Yes, ma'am.
Up to 93 days. You understand that?
Yes, ma'am.
All right. And you had enough time to talk with your attorney?
Yes, I have. Yes, ma'am.
And you're satisfied with her representation?
Yes, ma'am.
And it's your intention to plead?
Yes, ma'am.
Is this of your own free will?
Yes, ma'am.
No one forced, threatened, or coerced you or promised you anything, is that correct?
I can hear you say again.
No one forced, threatened, promised you anything, or coerced you in any way to plead? All right. As to count 1, on or about March 12th, 2026, having contact with minors at your residence, how do you plead?
Guilty.
As to count 5, from February 1st, 2026 through April 30th, 2026, failure to attend 7 of your 12 mandatory sex offender treatment classes, how do you plead?
Guilty.
As to count 6, as of May 29th, 2026, failure to make any payment toward your court-ordered restitution, how do you plead?
Guilty.
Sir, you understood the terms and conditions of probation, correct?
Yes.
And you understood because of the charges, both counts actually, you were not to be with any minors unless there was a supervising adult with them and you obtained permission. You understood that, correct?
Yes, ma'am. I told my
I'm sorry?
I said yes, ma'am. That one is my mom's birthday, so my baby came in town.
Well, you can tell, first of all, I didn't understand a word you said. Second, I will ask you your explanations. I just am asking you if you understood the terms and conditions of probation.
Yes, ma'am.
And you also understood that you needed to complete all of your treatment, and you failed to do that as well, correct?
Yes, ma'am.
All right. Were you ill, incarcerated, or something else where you could not comply with my orders?
Yes, no, I
I've not the excuse yet. Were you ill?
Okay.
Were you in a coma?
Okay.
Were you incarcerated?
Okay.
So you could have complied with the orders of this court. Is that fair to say? All right. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. I also find, based on his own admissions, that he did violate the orders of this court and should be held in contempt. Now, what is the recommendation of probation?
Thank you, Your Honor. Including the jail time, the defendant has already served up to today. He's got 317 days jail credit. So probation's recommendation is 45 days jail, is 90 days curfew tether upon release from jail. He is not to leave the state of Michigan until sex offender treatment has been completed. He is to enroll in sex offender treatment within 30 days of release from jail. And probation is also requesting that the capture and recovery costs, also known as the extradition costs for the defendant, be added to his probation, a total of $1,674 payable to the Ingham County Sheriff's Office.
So does he have, do you know if he has a place to live here?
He does, Your Honor. I spoke with him about it prior to this. He said that he has a grandmother who lives in the Lansing area. He also mentioned an uncle who also lives in the Lansing area. But In consideration of what he told me about how supervision was going in Georgia, that sex offender treatment was at least 45-minute drive away from where his residence was there, and he didn't have transportation. I feel that sending him back to Georgia is only going to set him up for failure again, because he's got no way to get to the classes. At least here, he can catch a bus, speak with his aunt, much shorter distance to get to Burgess.
Did he complete anything?
He did. He completed his domestic violence programming on October 13th, 2025.
And what about GED?
I don't have any reports that it was completed. I did have a report that he was attending. But that was unfortunately part of the issues with the violations or the violation allegations.
Thank you. On behalf of the people?
Thank you, and I would just echo probation's request. Yes, Your Honor, as part of the plea, we would also ask that you follow the recommendation of probation.
Sir, what would you like me to know?
Yeah, with the being my righteous stuff is my birthday.
Okay, sir, I need you to slow down and enunciate. The court reporter can't understand you, nor can I. And if you wanted to appeal this, the record that the Court of Appeals looks at is what we're making today, right here. When we're all gone, there's no record. And the court reporter needs to capture every word so that there's a fair review of what happens here. So this is in your best interest to speak slowly, a little bit louder, and enunciate. Thank you. You may proceed.
Yes, ma'am. No, I was saying what they told the argument.
I still don't understand you.
No, I was saying that what they told the argument.
Who's they?
My attorney and my probation officer. I told them that I agreed to plead guilty and
I told them.
I told them that I agreed to plead guilty and taking do my 45 days and staying in Michigan.
Okay, but what happened where you couldn't comply with my orders?
It was I had problems with transportation.
Okay, you don't have any problem talking or asserting for yourself, do you? You could have worked it out with probation there, right? Or here, could have let me know.
Yes, ma'am.
But you didn't do any of those things.
Yes, ma'am.
So how many more GED classes do you have?
August is supposed to be my last month of my GED program. I got locked up.
I got what?
No, I'm saying August is my last month of it, and I got locked up, so I couldn't finish it.
Are you working?
Yes, ma'am. I worked at Little Caesars in a lawn service, and I also have a photography business.
You have a what?
I have a photography business, and I also
photography business?
And I also work at Little Caesars and a lawn service with my mom's boyfriend.
You take pictures of children in your photography business?
No, ma'am.
Tell me about having children at your residence.
It was me and my mom's birthday, so my family had came to come talk, visit us and stuff like that. So everybody was there, aunties, uncles, cousins, everybody was there. It was a big family event.
So, sir, all you have to do is let us know. We're used to that. Holidays, kids get together, all that. As long as you were not left alone with them, I mean, that's just a violation that doesn't need to be.
Yeah, that's my probation officer. He was like, "Oh, I'm gonna look into it." He never got back to me about that. I did let him know that though, because it was a surprise birthday, so I didn't know that was coming to town. So I had to the day of. So. I did let my probation officer know that I had my family was there, and he said, "Well, I'm still going to violate you." I told him it was a birthday party with my mom.
Okay, sir, if you don't hear back, just call every day. If you don't hear back, you write me a letter. You call my office. You'll let my judicial assistant know. She'll call probation or whatever. We'll figure it out.
Yes, ma'am.
So this just can't happen again, because here's the thing: you're going to be out of jail time. From jail, when you're out of jail time, if you continue to violate, not take this seriously, you end up going to prison.
Yes, ma'am.
Okay, so
Understood.
you got a 4-year felony here. So just so you understand, if you violate, the most I can do is 32 months to 48 months. So 32 months is about, about 3.5 years. How's that sound?
That's all good at all.
Let's get your act together.
Yes, ma'am.
Can he do the sex offender treatment in the England County Jail?
Unfortunately, I don't have that information, Your Honor.
I'm not sure, the program sort of come and go, so I don't know. Okay. And who lives with your grandmother?
It's just her herself.
And who lives with your uncle?
My uncle, he stayed by himself as well.
Is there a preferred residence?
It's my grandmother, 5810 Orchard Court.
What was the address? Nice and slow.
5810 Orchard Court is my grandmother's address.
I did speak with the agent who did his PSI originally. She did agree that she had spoken with his grandmother at the time, and she seemed like a very supportive candidate for the defendant to reside with.
Okay, sir, I'm giving you, how many days jail does he have? How many days has he been just on this warrant?
Just on this warrant, 13 days.
Okay.
The original, at sentencing, he had 22 days jail credit, and then he served 282 days before he was released on August 23rd, 24.
Okay. So you included that in the 317, the 13 days?
Yes, Your Honor.
Okay, thank you. All right, I'm giving you 365 days jail. You will do, you can be released after you serve 350 days of that. The balance will be held. No earned early release, no tether release, no trustee status. So you'll serve all those days and you just get the statutory credit. I've left a few days just in case you need another little reminder, although I certainly could send you to prison. You are going to report to the probation office within 24 hours of your release. You will reside with your grandmother at the Orchard Court address. You will have the 90-day GPS curfew tether. You will have a curfew where you will be inside at 10 p.m. And it'll be 10 p.m. to 6 a.m. You will complete your GED. You will enroll within 14 days into the sex offender treatment program that probation will figure out is something that you can get rights or attend if it is within a radius where you can work it out. And as to the extradition costs, you now owe an additional $1,674 to the Ingham County Sheriff. You'll pay that through the court, so we will monitor that. You will be gainfully employed and be part of a work seek program. And I don't want any under the table job. What I want is something with a 1099 or W-2.
That's fine.
And you will arrange a payment plan, and a wage assignment will come out of his check for restitution and extradition. I'm not assigning him any additional costs for attorney fees, probation oversight. He'll have to pay the state costs that were already ordered, and I think that it was just the state costs and the crime victims. I think he can get the, in terms of the tether, can he get?
I don't believe that can be waived, Your Honor. I know Your Honor waived the original supervision fees, but I believe the additional $30 on top of each month for the tether fees have to be applied.
So is there a grant for that? Isn't there an indigency grant or no?
I don't believe so, but tell my clients worry about your supervision fees much, much later and focus on restitution anyways. And I would tell him the same thing.
Which teller has the indigency grant? Because there is an indigency grant.
JSG, Judge.
Oh, I'm sorry?
JSG.
That's only for pretrial release. But that's through pretrial. Yes. So are you telling me we don't have one for after pretrial?
Not that I'm aware of, Your Honor. I believe that MDOC teller is the cheaper of the two options. We're looking at cost effectiveness.
Okay, well, put him on whatever teller is cost effective and gets the job done. You're not to leave the state without permission of this court. Is there anything else I need to order? I think it was all ordered at time of sentencing.
I would just recommend that the condition about not leaving Michigan until the sex offender treatment has been completed be added.
Oh, he's simply not leaving Michigan right now. I don't know why would I let him go back to Georgia?
In that case, I would recommend we remove the condition about allowing transfer to Georgia.
Okay, remove that condition. You're not going back to Georgia right now. You need to go, if you go back to Georgia, I want guarantees you're going to comply. What were you doing in Georgia?
I was working.
Well, we have Little Caesars here, right?
Yes, ma'am.
You were doing lawn care?
Yes,
We
ma'am.
got a lot of lawns and snow removal here.
Yes, ma'am.
And you can take a picture anywhere in the world, right?
Yes, ma'am.
So any reason you need to go to Georgia?
Not at all.
Great. You're a Michigander now. Anything else?
No, Your Honor, I believe you covered everything. Thank you.
Thank you. Sir, you have 42 days to appeal and to request appellate attorney. Please give me his appellate rights since I have found him contempt of the jail. So we just to accept that, sir. Do you want, if you'd like to appeal this, that's what you use, all right?
Okay.
Good luck to you, sir.
Alrighty, friends. TCF Live on a Tuesday. It is good to have you all here with me. Barbara, thank you for gifting 5 memberships. And Todd, thank you for gifting 5 memberships. I appreciate you both. And to all the new members, welcome. Let's go back to Texas, check in with Judge West. Judge West.
And this is cause number 21-36605, and Mr. Brandon is charged with murder. And what is the announcement?
Judge, I just received the insanity evaluation from Dr. Gopal yesterday and spoke to first assistant elected yesterday. After receiving that, we would like to have a second opinion. So we're going to get an evaluation done on our own, make sure that they coincide based on his criminal history and history with this particular victim.
Okay. So I'm going to do just a normal reset. Obviously, this has been going on for a long, long time. And so if y'all can get that done, ordered very quickly.
Yes.
Obviously, Mr. Lane, if you want to be there and present for that, if y'all will coordinate, if you want to be present for that evaluation, but let's get that evaluation done quickly. And then I want an announcement of the next court date.
Yes, sir.
All right. Thank you. You can go back with the bailiff. See, Miss Akorafor, did I say that correctly?
Judge, Mr. Coleman wanted to continue to handle that case. He's next over. His message to be over in just a second.
Okay, I'll hold it for just a second. That's on Jonah Johnson.
Yes, Your Honor.
Okay, thank you. Mr. Radford, you have Jacobian Dorsey.
Yes, ma'am.
Dorsey?
Set the case for trial.
Did you do a rejection?
I think it's already been done, but you know.
Let me, I'll check real quick and see. Was there anything, hold on, you might not have to do one. Is there anything that's,
I think he's already, I think I combat lawyers.
You looking?
we're not gonna call them that.
Okay, I'm sorry.
Mr. Coleman's notes look like he hasn't changed the offer or anything, Your Honor.
Looks like, the offer was 20
Yes, stacked.
to stack on top of a sentence he's doing now, correct?
Yes, ma'am.
All right, so you're Jacobian Dorsey?
Yes, ma'am.
And Mr. Dorsey, in cause number 25, DCCR 1896, you are charged with manslaughter. And we've gone over this before. Let me pull it up. Is there the indictment alleges second-degree felony offensive manslaughter, but looks like the state's filed a notice of intent to use prior conviction to enhance your punishment, which means we've gone over before. And when you sign that plea bargain rejection with Mr. Parker, that the state, you would be looking at a first-degree felony if you're found guilty for punishment purposes, which means the minimum punishment would be 5 years up to 99 years or life in prison. You understand that? And the same offer is on the table now, which is a 20-year term in prison that would be stacked on top of a sentence that you're currently serving. Is that your understanding of what they've offered you? And you want to reject that and move forward with trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Radford will begin preparation for trial.
Excuse me. That time that I'm actually going to sign for right now already, that's on appeal.
Okay.
So that's not a full conviction.
All right. Well, if it'll all depend on when we get to the trial. I'll set it on the trial docket. If something gets affirmed by then the conviction would count. If not, then there's some legal issues that we'll take up at that time, which means it would be potentially just the 2 to 20, but we'll take that up at pre-trial.
Judge, it looks like a case has been brought over this week from something that happened in the jail. It may be a new harassment or assault on an officer. I think that's going before the grand jury tomorrow, if not tomorrow, next week. And I just asked that we put this on the trial docket. I don't think it's going to change.
No, yeah, we're going to go to put this one on the trial docket and then we'll deal with that one when it comes.
Thank you.
Thank you, Mr. Nichols. You can go back with the bailiff.
May I be excused?
Yes, sir.
Thank you. Yeah, I'll go back. What do you need to learn? You gotta go into the Pauline cell and out. This is.
I'm gonna call him.
All right, well, she racks up another contestant. Let's stay in Texas, but we'll keep with this channel's long-standing promise of 9 to 11% more Judge Boyd and go to San Antonio.
631 State versus Jeremy Alvarez Perez. Can I have parties announced?
Pretty bill signed for defense and clerk. Right for the state.
And excuse me, miss, and what's your name?
Madison Johnson.
All right.
She's an intern in my office, Judge. She's a 3L, a rising 3L.
All right, so he's your supervising attorney. We should put your name on the record.
Thank
you. All right. So, Mr. Perez, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Jeremy Alvarez Perez who was placed on deferred adjudication in 2022 CR 8631 for the offense of aggravated assault with a deadly weapon on November 29, 2022 for a period of 7 years? Is that you?
Yes, ma'am.
All right, state.
Judge, we proceeding on a violation of condition number 40, specifically that on or about the 5th day of March 2026 in Berry County, Texas, the defendant, Jeremy Alvarez Perez, is then and there failed to abide by the TCF program in violation of condition number 40.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 40, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 40?
Yes, ma'am.
Court will find violation of condition number 40 true. Is there a proposed agreement?
There is, Judge. The agreement is to go along with the recommendation of probation, which is to alter amend for GPS with curfew, evaluate for ISP supervision and TAP, as well as add regular UAs for the defendant's self-admission for THC consumption.
Here's my question. What's this, the failure to abide by the GPS program? What does that actually mean? What did he do or is alleged to have done?
Yeah, moment, Judge.
Yes.
And Your Honor, if it's correct to give some.
Sure.
Basically, this seemed to be an issue that he was having, and this is my counsel with him, with the battery. And that seems to, and that is addressed in the documents and how he.
What I want to know is, did he cut off the monitor?
No, Your Honor.
No. it looks like from what happened, the GPS monitoring device router went dead and they were no longer able to track him through the GPS system.
So
Further,
when did it go dead?
on March 5th, 2026.
And when was he arrested?
It would have been recently judged within the last few weeks.
Oh, say, okay, so from March 5th, 2026 till now, and I'll just give him till June. Let's say June 1st. Was there any contact with probation? Because his monitor is dead, so where is he?
I believe he, and again, this is in my consultation with him, was contacting probation. There was some confusion as it relates to that. He works, he's a welder, works with Armadillo builders. He's been at home, and they were trying to figure that part of it out. At some point, it should probably be confirmed in the notes, the probation said that he needed to come in, I believe, right? And then, but I don't believe he came in that day that they said for him to come in. Is that accurate?
So we need to have Ms. Abrams come back because there are some questions I have with the GPS issue.
Yes, yes.
All right, so she should be back in a few minutes.
Thank you.
All right, thank you.
Okie dokie, friends. Let's go back to Judge West, new contestant finally arriving.
And are you Alexis Yell? Yes, ma'am. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Yell, in cause number 22-40915, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 4th of 2023 for the state jail felony offense of credit or debit card abuse, and that was a 4-year deferred probation. Is that correct? Yes, ma'am. This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of driving while intoxicated with a child under 15. And is that true or not true? True. Count 2 alleges that you failed to abstain from the use of intoxicating substance, including alcohol, and that on March 22nd, you were intoxicated or under the influence of alcohol. Should that say the same date? The first one says March 20th and second says March 20.
With the court's permission, I'll amend to make that the 20th.
Any objection?
No objection.
So it's just alleging that you were intoxicated on the same day that you were arrested for the DUI. Is that is that true or not true?
True. And Judge, I think we've agreed to abandon counts 3 and 5.
Judge, we can drop 3, 4, 5, and 6. It's all right with the court since we have an agreement.
Thank you. State will abandon 3 through 6. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? Yes. And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Yes. Did you fully understand them? Yes. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Yes. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Yell is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and your plea is of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty and find you guilty of debit or credit card abuse. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison.
Judge, the agreement to 1 year in the county jail.
Good grief, I'm all out of whack. 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. Thank you.
Thank you, Your Honor.
Thank you, Judge.
All right, friends, let's head back to Judge Boyd's court. The defendant from earlier is back, so let's finish that.
I'm sorry, just 1 second. It's kicked me out of Odyssey again. All right, so on this case, what is the report back from the court?
Your Honor, we, talking to probation, he did make, phone contact. His phone contact with him, but this was in March. The phone contact, he was told that he needed to, check in with the GPS folks to get the issue addressed. In my conversations, all of this lines up with what he was telling me when I met with him at the jail. That he didn't really know what to do, but he kept it because he didn't think he was in trouble and that it would work because he didn't cut the monitor. He's not necessarily, technically proficient, but that's pretty much where we are. And then when it didn't pick back up, the state, that looks to go in alignment with the MTR itself. That's when they put it up because he needs to come into compliance with the GPS monitor. But he did call.
All right, probation. What is your recommendation in this case?
Judge, on the court summary, it says to alter and amend for GPS with curfew, evaluate for ISP supervision and a TAP. And follow all the recommendations of the TAP.
Fundamentally, Judge, I think he's been a good probationer with the exception of this issue. Fundamentally, with the exception of that first blip on the screen he had, and he did fall in line. He does have 7 children with him and his wife that he does support. He's a welder. Works with Armadillo Building. He is.
I don't know why when people have issues with certain things, they don't come to the court and ask. I tell everybody to come to the court if there's an issue. And your technical proficiency, you have enough proficiency to know where to go to get a bunch of tattoos, right? And people should know how to pick up the phone. People should know how to come to court. You know where the court is located. All right, I'm going to give you a choice. These are your choices. There are no other choices. Number 1, you'll stay in custody until the TAP evaluation is completed. You will be placed back on GPS, and I will do GPS with a curfew. The exception, Ms. Abrams, will be his work hours. If his work hours are outside the curfew, then he's allowed to go to work. Or I can revoke you and sentence you to 4 years in the prison. Which do you prefer? I mean, well, your attorney here's the thing. It's nice to look to your attorney for advice, but you know yourself better than your attorney does, better than probation does.
I don't have a problem with doing probation.
Well, no. These are your 2 choices. I can sentence you to 4 years, or I will continue you. You're going to do the TAP evaluation in custody. You're going to have a curfew, and you're going to be considered for ISP. Did they ever do a gang evaluation? I don't. All right. So which do you prefer?
The TAP evaluation.
All right. As previously stated, the court is finding the violation true. The court will deny the motion. Alter and amend conditions to the following. TAP evaluation in custody. If for some reason they release you and they're not supposed to, next business day, you better be walking into this court and say, hey, I've been released by mistake. You understand?
Yes, ma'am.
There's going to be GPS waive fees with curfew until further notice. Ms. Abrams, what do you want the curfew hours to be?
Judge, 8 p.m. 6 a.m. to 8 p.m. 8 p.m.
All right, so excuse me. Yes. So you say 8 p.m. to when?
6 a.m.
6 a.m. That's your curfew. The only exception to that curfew will be if you're out because of work and you'll need to provide proof.
Yes.
So is that partial, Judge?
No, it's just GPS with a curfew. Okay. All right. Partial with curfew. And I want an evaluation, a gang evaluation, and ISP. Probation, is there anything else?
He's still waiting custody for that tap, correct?
Yes.
No, there's nothing else.
Anything else you need from the court? All right, good luck to you.
Maybe excuse Your Honor.
Yes.
Alrighty, friends, now in hour 3 of TCF Live. This day, like all others, rolling right along super fast. Back up to Michigan. Judge Aquilina, new contestant there.
Versus Paul Tucker. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie Maycomber on behalf of the people. Second to my right, probation agent Joshua Russell. Aaron Robinson, Assistant Public Defender for Mr. Tucker.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, you pled no contest to domestic violence and or assaulting a pregnant individual, second offense, which is a 1-year misdemeanor. And you had probation conditions, and it looks like you could not finish those. I have an allegation here that says on December 7th, 2022, defendant was sentenced to probation. Defendant failed to report to the probation office. So before we proceed, since when did you report, or was that at any time?
Yeah, at that date or any date thereafter, which would make it a non-technical violation, Your Honor.
So I'm amending this to read defendant failed to report to probation office at any time.
Correct.
After sentencing. Any objection on behalf of the people? Behalf of the defendant?
No, Your Honor.
Thank you. Sir, have you taken any medication yesterday or today?
No, I have not.
Are you supposed to be on medication you're not on?
No,
Any sign of fever, COVID, or other illness?
no.
Have you had an opportunity to speak with your attorney?
Yes,
Do you understand the allegation that is against you at this time and why you were arrested?
yes.
Counsel, are you waiting for further arraignment?
We are.
All right, and sir, I can revoke probation, I can sentence you up to a year, I can hold you in contempt for 93 days, and or $7,500. You probably don't have the money, but you got the time to understand what I can do.
Yes, Your Honor.
And this is not beyond a reasonable doubt. If you went to a hearing, it's by preponderance of the evidence being more likely than not. Do you understand that?
Yes, Your Honor.
And is it your intention to plead to this or go to hearing?
I'd like to plead to it, Your Honor.
And you made that decision after talking with your attorney?
Yes, Your Honor.
You've been satisfied with the representation of your attorney?
Yes, Your Honor.
Did anyone force, threaten, coerce you, or promise you anything that's causing you to plead?
No, Your Honor.
As to count 1, on December 7th, 2022, after being sentenced, you failed to report to probation at any time after sentencing. How do you plead?
Guilty.
And sir, I was very clear about what you were supposed to do, correct?
Yes, you were, Your Honor.
And I put you on probation for, it says 18 months, or it's probably 12 months. I don't know, I don't usually do the 18 months, but nonetheless, you're on probation for what it says here, 18 months. And I may have even explained you only had to do half of that, but you had to comply with all of the requirements so we could make sure that you were rehabilitated, because probation is for rehabilitation. It's really not a punishment. Jail is a punishment. So you knew you were supposed to report and then follow all of the orders, correct?
Yes, Your Honor.
And you failed to comply with anything.
That is correct, Your Honor.
All right. I find defendants plea really voluntarily, knowingly and understanding made. It's been, it's very clear from this record and from defendant's own words that he failed to attend or complete anything, and he knew he should have. Therefore, the court holds him in contempt. What is the recommendation of probation?
Thank you, Your Honor. Probation would recommend that probation be revoked and that the defendant serve the 365 days as originally ordered and held in abeyance by Your Honor. Thank you.
On behalf of the people.
Thank you, Your Honor. I ask the following recommendation.
I'm sorry?
We have to follow the recommendation.
You have a reply?
Yes, Your Honor, we would ask for a reasonable jail sentence in regards to this offense. Mr. Tucker is currently incarcerated and he has another open case as well. So we would ask for a reasonable jail
What's
sentence.
that open case and where is he incarcerated?
He's here. He has another open case here in Ingham County.
Before me?
No, it's in 54A District Court, but he's incarcerated here at ICJ.
What's the charge?
Domestic violence.
Tell me he's not with the same victim. The victim here was Stephanie Allen.
It's not the same.
Sir, without talking about your other case, what would you like me to know?
Your Honor, at the time that I was sentenced to probation, I was actually pretty deep involved with alcohol and drugs as well. Within 3 days of after being sentenced, I ended up losing my job because of alcohol. And that's what caused me to lash out. And within the last few years, I've, for the most part, brought my life back together by getting an apartment because I was homeless after that. And I also maintained a full-time job where I was actually management. Usually when I'm not drinking, I am not a violent person. I usually don't make any mistakes, but when I'm drinking, I make all the mistakes in the world and I really need help.
You're a mean drunk. You knew that though, and you continue to drink. So who do you live with now?
I'm by myself now.
So what's gonna happen to your apartment if I sentence you to a year?
It's gone. Which is my own fault. I mean, I brought this upon myself.
Is there anyone who can empty your apartment?
No,
Where's your family?
they refuse to help me. Because of the alcohol, because I should have got help a long time ago. I should have checked myself into rehab, honestly.
Do you have any friends?
Not really. I mean, I got coworkers, but that's about it.
The reason I'm asking you, sir, is you are going to do some jail time. And we see a lot of this where you are incarcerated, now you're going to lose your apartment with all your belongings, including your ID and your birth certificate and your passport or whatever else you got. They're just going to put it in the street. That's not fair.
I know.
So anybody have any solutions? You don't have anybody who could go and clean your place?
No,
So when you go out drinking, who do you go out drinking with?
I'm an isolated drinking, Your Honor,
So why are you alone in the world?
because of my decisions in life of drinking. The friends that I had were pretty much junkies and alcoholics, and I've been trying to, stay away from that and trying to live a better life.
So, do you have any money in the bank?
Tomorrow I'll actually have a deposit of $900, which will cover a month's worth of rent, which I have auto pay.
What's the bond on your other case?
The bond on the other case is 10% or cash assurity of 150. So I think that's about 1,500, I believe.
So he was charged with another misdemeanor?
No, Your Honor, it's a domestic violence third offense.
So it's coming back up to me?
Theoretically, yes.
Is there a preliminary exam set or what's the status? Do you know?
There is a preliminary examination set for this Friday, Your Honor. My understanding is that the victim has been served and is going to be appearing in court. And his bond is set at 5,000, cash surety, I don't see that it's at 10%.
So looking at your criminal history here, so it's all intoxicated, intoxicated, domestic violence. You've had a number of, let's see, going back to 2008, operating while intoxicated. Domestic violence, operating while intoxicated, breaking and entering a vehicle. Not surprised. Domestic violence, operating while intoxicated. Domestic violence. There's also personal protection order, 2021. Okay. Where are your parents?
Mainly deceased. I have my father.
Oh, mainly deceased? You can't be mainly deceased. You can't be partially deceased. They're either deceased or they're not.
I'll restate this, Your Honor. My father is in Lansing, but basically has disowned me.
Okay, not surprised. What about your mother? Did she pass?
She hasn't been in my life since I was 3 years old.
So were you adopted? What's your family situation? Regardless of whether you're connected with them or not.
My father raised me since I was a child, basically on his own.
Okay, how about siblings?
Me and my brother do not get along at all.
So you have a brother?
Yes.
Okay, I take it he's a sober brother?
No.
He's not sober.
He's also wanted and probably for drug charges and whatnot.
Okay, and do you have, I thought I already had a child. Do you have a child?
No, I don't.
Okay. So what, and you don't have to tell me, but do you know why you're drinking?
I mean, I think it stems because my father was an alcoholic as well.
Yes.
And I try to pinpoint my reason of drinking. Sometimes I feel it's because I'm depressed, but also times that I'm happy, I drink as well.
Oh, I think you're depressed. I think you have that whole aura about you. You're not happy. You're not a happy person. You don't really give a crap. And you don't care if I sentence you to jail or prison. You really don't care what happens to you.
No, it's not necessarily true. I mean,
Not sure.
Sorry, right?
It is true. This record speaks to that. Your mother left you when you were 1, and I have a feeling that you have some kind of abandonment issues, like why wasn't I good enough for mom to stay and save me from a drunk dad? You got a lot of stuff going on. I can see it. I can feel it. You just got this pain that you've been shoving down with alcohol. It is not a good enough excuse to say, well, my daddy was a drunk, so I can be. It is tougher. I agree with that. There's science behind that. But you also are a grown man and have choices. And you also have got a history here that tells me that you have felt abandoned, unloved, and you've chosen to abandon yourself as well. You have to be your own best friend first, and you're not. You're a good worker. You've been able to get jobs, get back on your feet, all of that. So here's what I'm going to do. I'm going to continue this sentencing until after the other case comes to me. Because I think you need to go to residential treatment long-term. Also think you need to go out and get your things in storage. I really think that it's an unfair punishment for you to lose your belongings and your ID and everything else and start in negative numbers. That's just not what we're about. Do you deserve punishment? Sure, but you need some treatment so this cycle stops, because the next stop for you is either going to be prison or a body bag. There's a fork in the road here, and you can take a sober life where you deal with your issues and decide that you're a valuable human being and prove it to yourself and your community. Or you can go the other route where you kill yourself, maybe take someone in the community with you because you're driving drunk, or you die of cirrhosis of the liver, or any number of things that happens to alcoholics, and none of them are pretty. So I am going to set this for, let's see, Monday at 11 o'clock. Can everybody make it? And then we'll know the outcome of the bind over, and then that case will be mine. And then what we will do is, and if probation could perhaps look at a rehabilitative program for him, long-term residential for anger management, battery intervention, alcoholism.
I'm out that day, Judge, but I mean, I can
We
find
do it
coverage.
Tuesday.
Yeah.
Or you can find coverage, it doesn't matter. There's somebody else in front of me. Or we can do it Tuesday, it's okay with me.
Yes, Tuesday's fine.
Great, let's do Tuesday at 11. I don't know what my schedule is, but I'm here, pretty sure, so. And if probation, prosecutor's office, and defense counsel could just let me know what happens at the preliminary exam. I'm assuming it's gonna get bound over, but who knows if she shows up or whatever, I don't know. And then I would like to know the options for long-term treatment. Should I revoke him? Yes, but what am I doing? I'm revoking him to kill one of us. He's gonna be a drunk driver again. And I don't wanna go out with him. And I don't want anybody in our community to be put in that position. Sir, clean up your act.
I appreciate it.
You thank me by staying clean and believing in yourself. Drop the bag of rocks you're carrying. You got some pain in there, whether you owned it or not. There's a lot going on there. So we need you in some intense counseling, and I will add to the orders as I see fit after I look at what's going on with the other case. Everybody good with that?
Yes, Your Honor.
Great, I look forward to seeing you, what did I say, Tuesday at 11?
Yes, Judge.
Thank you.
Ashley or Austin, if one of you could do me a favor and add that to the calendar, I think this is worth following up on. So, you know, Judge Aquilina can be tough as nails when it comes to defendants and sentencing and all of that, but I think she also tries to help, and that seems clear here, so hopefully we can get things sorted. They can get things sorted for this guy. Anywho, hour 3 of TCF Live. Let's go back to Texas and Judge Stevens.
Yes, sir. Okay, you're here with Mr. Dusler, your attorney, right? And you're charged in 2016 or 859 with the state jail felony of theft of a value, it's a vehicle of more than $2,500, but less than $30,000. So this carries with it up to 2 years in the state jail if you are convicted. What are we going to do today, Don?
I asked for 4 weeks, Your Honor.
Okay, this is, she just
Yes.
got indicted
Yes, sir.
today. Then you got 4 weeks, get a resetting. Criminal history, if any?
None.
That you're aware of? No?
I did not check that, Judge, but no, that's fine.
I have race. Is it race? How?
You should have a plea in your paperwork, Judge.
What's going on in there? What's going on?
She's
that's
redressing some of her
wait.
grievances.
That's Judge West?
Yes.
Raving on? That's Judge West? You said it's next door, the judge.
It's her jail.
I can't believe, because she's such a lady.
I need to swear the defendant in and fingerprint him.
She's gonna swear at you.
Raise your right hand, you swear or.
Uh,
Because you're right. These whole documents here, is this. Okay, so it's flat on that box right there. Okay, do it one more time. One more time. One more time. And do it right side down.
Totally right in the other.
So yeah. Let's see it.
And we now call 25 CR 820, the state of Texas.
Repeat that number.
Grace Hall, and that's 24 CR 2257. Great, is that your first name, Grace?
Yes, sir.
Was that a family name?
No, my dad used to race motorcycles.
Oh, okay.
We know.
He didn't want to call you Harley? Okay.
Yeah, he used to ride dirt bikes.
That's just a thought.
Weak material this morning, I think. Awesome.
Well, it had to be soon.
Yeah, this has to be, I guess.
But seriously, getting down to what we're dealing with here, Mr. Hawa.
I need to wait on.
You're charged in 24 CR with a third-degree felony of evading arrest or detention with a motor vehicle. And in all seriousness, it's a serious crime. It carries with it up to 10 years, a decade in prison. Plus, if you ever got a felony conviction, you know how long that lasts? The rest of your life. Yeah. Yeah, I think they throw it in the grave with you. So it'll carry on to the hereafter. But anyway, serious, fixable. You ever been in trouble before? When you looked over to her, you were. This
was my first incident.
That's right. You've never been in trouble before.
Not before this.
You thought there, you looked and thought for just a second. Everything else had been fixed, though. Any mistakes you've made, you've put them behind you. All right. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
We do, and yes.
In summary, this indictment alleges that on or about September 9th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with here, sir?
Yes.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're looking at?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, but not found guilty. You're getting a rare second chance. Make the most of it. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. Then there will be terms and conditions of probation, which are normal and customary for this type of offense.
Yes,
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Plead guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
Understand it? Discuss it with your attorney. Are the contents all true and correct?
All this is true. Yes,
Okay,
sir.
State's Exhibit 1 tendered in.
No objection, that's fine.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and the indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are given your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true and states, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Please.
I'm going to follow this agreement, if nothing further. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of this probation order that is coming forth. Make sure you do, and there are a lot of terms, 30 some odd conditions, but the overwhelming majority of these are requirements I have to follow and your attorney has to follow. Commit no crime, avoid injurious habits, don't associate with disreputable people, work faithfully, support defendants. I mean, don't use or possess illegal drugs. You know, these are recipes for good behavior. Yeah. So it's not as much punishment as more of a blueprint for exemplary behavior.
Judge, based upon his lack of criminal history, age, and the facts of this case, we have a joint recommendation of 3 years for the length of probation. I would also like to add that he's, based upon the time of the indictment, he's followed all the conditions of his bond and made all court appearances as we've worked to resolve this.
Also, you're going to be required to take and complete defensive driving, which is a good thing.
Mm-hmm.
It'll remind you about how you should operate a 4,000-pound missile responsibly, but also your insurance will go down because it's going to go up with something like this if you're using a motor vehicle. So we're kind of balancing out the harm that was being done. Also, I can, as a condition of probation, I can place you in jail for 6 months. I'm not going to do that, but there's a thought of it. Did the thought of it surprise the heck out of you?
Yeah, we've had that discussion.
You had that discussion. Well, you don't want to go to jail.
No.
How long were you in custody? An hour or two? Or
I've been with this case, I was in jail for 2 days.
okay, how'd that work out? Life went on the outside. You know, it passes you by. Get in the game of life. Follow the rules. Okay, I'm going to place you on probation for 3 years. Make the most of this. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. That's what I don't know. Here's the probation officer. I'm giving that to her. You're going to see her sign and get this done and move on with your life. Okay. All right. Yes. Okay. And Mr. Grant, you knew you were clear. So did you get your resetting? Oh, possibly. Would you wait for me outside, please? Wait for me outside. Wait on me outside.
Alrighty, friends, entering the last half hour of TCF Live on this glorious Tuesday where we actually had rain here at the bunker a few minutes ago. Always a good time when that happens here in the incredibly dry, incredibly hot desert, where as Tot puts it, we're in training for cremation. Okie dokie, let's go across the hallway, Judge West.
Good morning, sir. Are you Joseph Curtis Jr.? Speak up, please.
Yes, ma'am.
And this is cause number 25 DCCR 1758. Mr. Curtis is charged with continuous sexual abuse of a child. And what is the announcement?
We would like to hold and not ready at this time. We have some mitigation we would like to get, and we haven't been able to speak with Ms. French.
Judge, I know that Mr. Johnson had reached out to Pam in after the last setting, and they were working on getting some information to her that I think is mitigation evidence. So I don't see a problem if it's all right with the board.
So this has been, it looks like Mr. Johnson substituted in December of 2025. I'm going to reset it one more time. That will be the final reset.
Yes, ma'am.
So whatever needs to get to Ms. French needs to get there quickly so that she can take a look at it. And if that changes anything with regard to an offer, y'all can discuss it and have an announcement before the next court date.
Yes, ma'am.
All right. Thank you. You can go back with the bailiff.
And I'm it's not to go for you.
Yes, ma'am. Thank you. Have a good trip. Have a safe trip back.
Yes, ma'am. Thank you.
All right, she's muted herself. Let's go back across the hall to Judge Stevens. But before I hit the go button, so this defendant walking up, he's kind of giving me Scotty J vibes, that character from Boogie Nights. Let me know what you think in the comments, but he kind of looks like Scotty J to me.
1, 2, and 3?
Yes.
Okay, all 3 paragraphs.
Yes.
Paragraph 1, sir, alleges that on or about May 5th, 2025 in Jefferson County, Texas, you committed the state jail felony of theft of metals, and it looks like copper, of a value of less than $20,000. If it were only that. But no. Paragraph 2 of the indictment goes on to allege that on April 26, 2011, in cause number CR 27676, out of the 253rd District Court of Liberty County, Texas, you were convicted of a state jail felony of illegal possession of a controlled substance. Paragraph 3 goes on to allege that on August 10th, 2016, which looks like about 5 years after the Liberty County conviction, you were convicted of a felony of illegal possession of a controlled substance, a state jail felony, out of San Jacinto County, Texas District Court. So paragraphs 1, 2, and 3 collectively constitute a state jail felony, but punished as though it were a third-degree felony, because your punishment is based upon criminal history as well as the circumstances of the crime. And convictions come into play. Felony convictions always come into play when determining punishment. So do you understand what you are facing here, sir? A term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
I do.
You like this. State jail felony punished as third degree. Agreement's been reached between the parties. You would be pleading guilty, sentenced to 2 years in the state, 2 years. He says, in the state jail, right?
No, sir. Yes, perfect. Third degree felony punishment.
PDC judge.
Is that your understanding of the agreement? 2 years in prison?
TCJ.
Mm-hmm.
Yes, sir.
You'll be given credit for all time you served in accordance with this case so far, whatever that is. And if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Yeah. names, all this. I wrote all this Jeff stuff on there. Okay, I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. The state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You've read it. You're guilty of the crime charged and any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation of whether your lawyer. All of this are true, so help you God. Correct? State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
No, sir. So we're going to reset this for sentence.
When?
Provided 4 weeks.
Okay. And again, how do you plead to this first paragraph in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir. Yes,
and those 2 prior illegal possession of controlled substances offenses, are those true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations in each case voluntarily and because they are true?
Yes, sir.
Anything else?
No, sir.
Will we set? Please get a resetting for sentencing. Thank you. Thanks, everybody. Probation, appreciate y'all. And everybody ready for trial? Let's see what happens. Everybody.
Alrighty, friends, he moves on to trial. We move back to San Antonio. New contestant was Judge Boyd.
Morning.
Oh, all right. Do y'all want to address the MTR?
Yes, Your Honor. I believe we have an agreement on this one.
Oh, y'all want to proceed with the MTR?
Yes, Your Honor. We have a waiver for that.
Thank you. All right, the court is calling 2025 CR 013-430A, State versus Michael Herrera. Can I have parties announced for the record?
Rick Pena for the state of Texas.
Good morning, Judge. Genaro Cortez for William Herrera.
And are you Mr. Herrera?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Michael Herrera's placed on deferred adjudication for abandoning or endangering a child with intent to return on January 8, 2026 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 2. On or about the 19th day of March, 2026, in Bexar County, Texas, the defendant, Michael William Herrera, did then use a substance, namely marijuana, and violation condition number 2.
How do you plead to that? True or not true?
True. Violation of condition number 19. On or about the 11th day of June, 2026, in Bexar County, Texas, the defendant, Michael William Herrera, did then and there fail to follow all treatment recommendations from Treatment Alternative to Incarceration Program, and violation condition number 19.
How do you plead to that? True or not true?
True. And our state will waive the remaining violations.
I'm sorry, what was the last violation number, please?
19.
So it's 2 and 19?
Yes, Your Honor. We'll waive the other violations.
All right, just one moment. Okay, I was wondering, because I was reading this motion to enter adjudication of guilt, and according to the judgment, it's a misdemeanor. And I was like, that's a state jail felony. However, it's attempted.
Yes.
So do y'all want to alter and amend the motion to revoke to read as an attempted abandonment or endangering a child?
Yes, I'm trying to catch up what's up with the so state will make a formal motion to amend the motion to go to reflect the proper charge, which is attempted abandoning or endangering a child with intent to return.
All right.
No objections, Your Honor.
No objections. Did you understand by pleading true to violations 2 and 19, the court could find it true, grant the motion, find you guilty, and sentence you up to a year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to violations 2 and 19? All right. The court will find 2 and 19 true. Is there a proposed agreement?
Yes, Your Honor, that is to deny the state's motion, alter amend conditions to include what TAP recommended, which is for intensive outpatient treatment with Bexar County, the IVR call-in line for the duration of probation, and monthly minimum UAs, and the MRT class.
All right. Are you asking the court to follow this agreement? Are you waiving your right to appeal? All right. When you're drug tested today, what are the results going to tell me? When's the last time you used?
Beginning of March.
All right. So why are you using and you're on probation?
My wife was admitted to the hospital for ICU. She was diagnosed with MS and she was about to lose her vision, and I was taking care of her young children. And after she was in the after she was in the hospital a week on, a week off, it was just stressful for me to take care of my children by myself.
All right. So how do you think other people take care of children by themselves? Children are going to be stressful.
It was just difficult because my wife was in the ICU and I thought she was going to lose her vision. She had a MS relapse and it was a really bad scenario. We have no family around, so it was difficult for me to visit her. We had to do online visual through the phone. It was just a difficult situation while she was in the hospital.
All right. You got to start making better decisions, because you're here for attempted abandoning of children with intent to return, and that was reduced from a state jail felony. And now you're still doing things that you should not be doing. And it seems that your go-to when things get stressful, doing marijuana and other things, you can't do that. So is your wife out of the hospital now? And who all lives in the home with you? Is it your wife and just the children?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm self-employed construction.
Okay. All right. The court is finding 2 and 19 true. We're going to do intensive, deny the motion, I'm sorry. Intensive outpatient treatment with probation. I'm going to ask for the MRT. Ms. Abrams, do you think this is an MRT issue, or is this more of a marijuana issue?
Other concern, MRT, right?
All right, so the court is going to recommend MRT. And do you think we need the IVR hotline? All right, regular monthly UAs. And I'm going to ask for field visits 1 time per month for 3 months. Ah. All right, well, we can't do the field visits. And we'll recall the warrant. Is there anything else?
Judge, there's one issue I talked to probation about. He was ordered to do an anger management class.
Mm-hmm.
I think he might have done the wrong one. It was for 4 hours. He might require a different one, but I just wanted to point the court.
All right, if you'll talk to probation and see if that's one's appropriate or not.
So Judge, the class that we took is a 4-hour class.
Mm-hmm.
The classes that are approved through their county are anywhere from 8 to 10 weeks.
Mm-hmm.
So we would need the court's permission to accept the class.
All right. So if you'll talk with Ms. Abrams and see if she thinks that's appropriate. If she thinks that's appropriate, then I will allow it. If she thinks it's inappropriate, it's not going to be allowed. You'll have to take the one that's normally given.
Very well. That's all we have.
All right, thank you.
And so the warrant will get recalled today.
No, I mean, she's going to let me know.
Oh, the warrant.
Oh, I've already asked that the warrant be recalled.
Thank you.
You're welcome.
Thank you, Your Honor.
Alrighty, friends, final few minutes of TCF Live for today. Programming note tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. We're going to dig into that case we saw in Judge O'Donnell's court a few days back, where the lady actually stole her sister's identity. So we're gonna go into that again. 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. When we end this stream in about 10 or 15 minutes, it will take you over there, so you can set a reminder for yourself. Okie dokie. Back to Judge West, I think.
What they've charged you with. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, 3rd or more. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also, as part of that plea agreement, sign the dismissal in cause number 25 DCCR 1211. I'm handing you the trial court certification, shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Ronald Barrett. Ronald Barrett. Looks like Mr. Nichols is on that one.
We've got it covered.
Yep, got it.
I'm just letting you know, I mean, y'all wasn't saying today. Actually, it's my case. They've been, most of it has been.
It said Tommy.
No, it's no longer says.
On my recent, sorry.
You've been around this. Sorry, case.
Good morning, sir. Are you Ronald Barrett Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrett, in cause number 26 DCCR 0890, you're charged with the state jail felony offense of unauthorized use of a vehicle.
Yes, ma'am.
And that's from January 28th of 2026.
Yes, ma'am.
The indictment alleges that you were previously convicted of unauthorized use of a motor vehicle August 3rd of 2009.
Yes, ma'am.
And after that was final, you were convicted of possession of a controlled substance March 22nd of 2011.
Yes, ma'am.
And then after that, convicted of unauthorized use of a vehicle April 14th of 2011.
Yes, ma'am.
And then again, unauthorized use of a motor vehicle June 26th of 2017. And then burglary of a building August 24th of 2022. And how do you plead of that charge?
Yes.
And are all those prior convictions true?
Yes, ma'am.
I don't understand this agreement at all.
Judge, the vehicle in question is a scooter taken from a known address. The complainant is well known.
And
Both me and the court.
I will also tell that there's been some cooperation with.
Okay.
Law.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And obviously you can tell that I don't like this agreement, but I understand, there's some circumstances that Mr. Nichols and Mr. Parker have, negotiated for that.
Yes, ma'am.
I want you to understand if you come back in here on another offense where you're stealing a car or getting into a building or stealing, I don't care if it's a scooter, I don't care if it's a Snicker bar.
Yes, ma'am.
You will not get an agreement like this again, regardless of what you've done. Do you understand?
Yes, ma'am.
Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
Objection.
It's admitted. Is there any evidence that Mr. Barrett's not competent?
No, you're right.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Also that you entered those pleas of true freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find this prior offense is true. Sentence you in accordance with your agreement to a term of 2 years in the state jail, in the Texas Department of Criminal Justice.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you.
Yes, ma'am.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
Good luck to you, sir. You can go back with the
Thank
bag.
you.
All right, thank you.
Can you go up for a second?
All right, friends, let's head back to Judge Boyd, a new contestant there, and we'll finish our day out with her.
All right, the court is calling 2018 CR 9330W State versus Fatima Osman Abdi. Can I have parties announced?
Megan Valley for state.
Jury will distributor for Ms. Abdi.
And are you Miss Abdi?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Fatima Osman Abdi who was placed on community supervision in 2018 CR 9330W for the offense of evading arrest detention with a vehicle?
Yes, ma'am.
All right, state.
Violation of condition number 5 in Bear County, Texas, the defendant Fatima Osman Abdi did then and there fail to report to weekly visit as directed by the court for the week of December 1st, 2020 through December 4th, 2020 in violation of condition number 5.
How do you plead to that? True or not true?
And then violation of condition number 5 in Bear County, Texas, the defendant Fatima Osman Abdi did then and there fail to report to weekly visit as directed by the court for the week of December 7th, 2020 through December 11th, 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. And then violation of condition number 5 in Bear County, Texas, the defendant Fatima Osman Abdi did then and there fail to report to weekly visit as directed by the court for the week of December 14th, 2020 through December 18th, 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. And we'll waive and abandon the remainders.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violations 5, 5, and 5, the court could find that true, grant the motion, sentence you to up to 7 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead to true to 5, 5, and 5?
Yes, ma'am.
Court will find 5, 5, and 5 true. Is there a proposed agreement?
There is, Judge. It's for the court to grant the state's motion, revoke the defendant's community supervision and reform the judgment to reflect the sentence of 5 years. 4 years.
That is the agreement we have, Your Honor.
All right. Are you asking the court to follow that?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow the agreement that you've reached. The court will sentence you to 4 years in the prison, give you credit for any time served. The court will request the therapeutic community. There's a $1,500 fine. Time and money will run concurrently. And there's to be no unsupervised contact with minors, and that's based upon the stipulations in this case and your previous plea bargain agreement. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. With regards to this case, was there any type of inpatient treatment or no?
Judge, from what I can tell, she stopped reporting in November of 2020. And I don't believe she did complete the TAC, but then it looks like she did a couple of UAs and then that was it, Judge.
No inpatient treatment, Judge.
All right, thank you. All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Excuse?
Yes.
Thank you.
Alrighty, friends, that draws it to a close for today. I hope you all enjoyed the show. I know I enjoyed bringing it to you. Thanks for all of your participation, your generosity, all of it. Never goes unnoticed, so thank you. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We will redirect over there at the end of the stream so you can set your reminders, so do join us for that. And we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, so I hope to see you then as well. The wisdom I leave you with today is from Ralph Waldo Emerson. Nothing great was ever achieved without enthusiasm. Quite right, Mr. Emerson, so true. I will see you all soon. Take care. God bless. Have a great day.